The Committee on General Laws and Technology will come to order, and the clerk will please call the roll.
You have a quorum, Mr. Chairman.
Thank you. Before we get started, I just want to explain the order of things. We're going to hear a report from the Gaming Subcommittee, but before we do that, we have three senators, or actually four if Senator Deeds makes it, who had schedule conflicts. So we're going to start with Senator DeStaff, and then we'll hear from Senator Spruill and Senator Boysko, and we'll work Senator Deeds in when he gets here. Okay, which bill do you have? 1062.
This on? 1062, correct a mistake in the 2022 amendment that made the person born prior to January 1, 2000, but who were interned after January 1, 1948, eligible for the funds through the Historical African American Cemetery and Grave Fund. What we failed to realize, Mr. Chairman, the mistake was made that we didn't realize that even though it's 1900, we didn't realize that somebody just might live beyond 1948 January. And all this bill is doing, grave of those born prior to January 1, 1900, but who were interned after January 1, 1948, make them eligible. I don't know who can live that long, but just in case somebody make it past January 1, 1948, before 1900, make them eligible. That's it.
Okay, so we're correcting an oversight from a.
You have a substitute.
Oh, there's a substitute.
Substitute. Thank you.
Okay, is there a motion to adopt the substitute in a second?
So moved. Second.
Okay, all in favor of adopting the substitute will say aye.
Aye.
Okay. And was the substitute a significant change, or was that just a technical change? What was that?
Thank you, Mr. Chairman. The substitute just clarifies that this is for people who were born between 1800 and 1900, and regardless of whether they were interred in that cemetery at that time. So it is a substantive change.
Okay. Are there questions for Senator Spruill from the committee? Okay. Is anyone against this fine bill? Anyone feel compelled to weigh in favor of the bill in the room? Okay. Anyone in Zoom here to testify on this particular bill?
Those in Zoom who'd like to speak on this bill, please raise your hand electronically. You have no speakers, Mr. Chairman.
Okay. I have a motion, a second, to report Senate Bill 1062. All in favor will vote aye.
Thank you, Mr. Chairman and members.
Okay.
Ayes 15, no 0.
Okay, now we have Senator DeStaff.
Mr. Chair, members of the committee, thank you very much for your time today. We have Senate Bill 1082, which is the Department of Veterans Services PTSD or TBI bill. And to kind of touch base, we have a substitute. And let me explain the substitute real quick. So on the substitute, we add to this 100% medical grade oxygen in U.S. FDA approved hyperbaric chambers in the Commonwealth. So we've added that. And then because of the, I'm going to try to get this right, because of the over-medication of the sixth step.
Mr. Chairman, I move the substitute be adopted.
Okay, we have a substitute to be adopted. All in favor will say aye.
Got it.
Aye.
All right.
Okay, any opposed? Okay, continue, Senator.
So basically, let me go through a little bit of the background. And we have a lot of highly decorated TBI veterans that talk about the life cycle of TBI, traumatic brain injury, PTSD. We know hyperbaric chambers, the real deal, helps you heal kind of thing. And when you talk to these highly decorated individuals, when it comes to PTSD, TBI, they talk about the 6 Ds or the cycle of the 6 Ds, which is deny, delay, deceive than drugs, deception, and death. And I'm going to give you a couple of examples real quick. My master chief from SEAL Team 2 worked for us afterwards, was working at an ice skating rink dressed as Santa Claus, fell down, shattered his elbow. And it got so bad that he had gangrene when it was trying to heal and not healing properly. So they gave him the choice. And they said, hey, we can try a hyperbaric chamber on you, or we can go straight to amputation. And this was back in early 2000 at the time, so we're talking quite a while ago. He went and did basically the equivalent of 40 dives, and they noticed it regenerated bone growth and spurred bone growth back in his elbow. Further along in life, he had a stroke and then did a second dive in the hyperbaric chamber. And I've got to tell you that I have a few more friends who have major TBI-related issues. This is as they've retired from the SEAL teams or they've taken position outside of the SEAL teams, and they're running into issues in life. And we get them into the hyperbaric chamber for one series of 40 dives or two series of dives, and it's just a tremendous difference in their lives. So what does this cost or save the Commonwealth? Well, right now, lost in the wages alone of the TBI PTSD veterans, we're looking at $522 million. When you look at the total economic loss, there's $2.1 billion. And there's a really good study, and I know a lot of people on here have a lot of time to read studies, but there's a really great study. It's called the Brain Wounded Veteran Brain Drain in Virginia. And it's a fantastic study if you get an opportunity to read it. But we're trying to just do the right thing, make sure they're 100% medical grade oxygen in US FDA approved chambers, and allow any hospital that furnishes a comprehensive treatment program that includes, that may include, there's a large group of veterans who do not want to be medicated. So it may include medication, psychotherapy, and hyperbaric oxygen therapy from an accredited program. And I really think that we should do the right thing and move forward with this bill. And with that, I know we have folks that are online to testify. We may have some folks here, but I'd appreciate the committee finding favor in this bill.
Thank you. Before we move forward, I understand that Senator Cosgrove had SB 1446. Does council know, is that bill identical? Okay. Have you spoken with him at all about rolling one into the other, or has he asked that you to do that?
Mr. Chair, we've already rolled the bills together.
Oh, we did that previously.
Yes,
I'm
sir.
sorry.
We previously rolled the bills
Okay,
together.
so that's
Senator
included.
Cosgrove was had asked me. I asked him if he was going to be here. He said potentially, but
That's okay. We will trust you to handle it for him if he's not here, for the two of you. So basically what we're doing is allowing Department of Veteran Services to contract with hospitals for PTSD treatment or traumatic brain injury. Is that correct?
yes, sir, that's correct. With the hyperbaric chambers, psychotherapy, and may include medication. And I got to tell you, with the veterans that I've been dealing with who've gone through the 6 Ds and stopped at the 5th D, they really want to push this instead of medication.
Okay. Thank you. Are there members of the panel with questions for Senator DeStaff?
Mr. Chairman.
Senator Reeves.
Senator DeStaff, the cost to train a special ops soldier is anywhere between $1 to $1.5 to $2 million to keep them going forward deployed, correct?
That's correct, yes, sir.
And our active duty component is doing some very similar things for those operators to keep them in the field currently, correct?
Mr. Chairman, Senator Reeves, that's correct.
So this is just taking them once they've done with their active duty time, getting them back to neutral.
Mr. Chairman, Senator Reeves, that's absolutely positively correct. And it's a great alternative to medication or over-medication.
Sure thing. Okay. Now, are there any other questions from members of the panel? Okay. Is there anyone in the room against this bill? Anyone in the room who'd like to speak for this bill? Yeah.
And
Okay, I have a
re-refer to-
motion and a
Re-refer
second.
to finance.
A motion and a second to report and re-refer to finance. Let's just ask if there's anyone in Zoom waiting to testify on this bill.
There are two speakers, Mr. Chairman.
Okay, if you could be brief and speak up as you're called by the clerk.
Robert Beckman, please unmute your mic and give your testimony.
There we go. Hello, Robert Beckman. Can you hear me?
Yeah, thank you, Mr. Beckman. Continue.
Yes, I am with an organization, Treat Now, 135 coalition clinics around the United States. We've treated in excess of 21,000 patients successfully. Hyperbaric oxygen therapy in clinics as well as hospitals in Virginia. There's 6 clinics in Virginia that qualify to treat. Down in Hampton Roads, there's a phenomenal facility that's treated hundreds of patients and dozens of special operations warriors successfully. That's active duty as well as veterans. This is a treatment which is saving lives and restoring normal life to wounded warriors out of the Wounded Warrior Battalion, Camp Lejeune in North Carolina, and across the United States. Veterans as well as active duty are receiving treatment. I'm in favor of this bill in the most emphatic way, and that clinics in Virginia, freestanding clinics as well as hospitals, be reimbursed. I'm hoping that the legislature will provide funding. There are 8 states which have preceded you, 5 of which have provided in excess of $3 million to treat veterans. Thank you for your time.
Thank you for your testimony. We have another speaker in Zoom.
Yes, Mr. Chairman. Michael Payton, please unmute your mic and give your testimony.
Thank you, Mr. Chairman, for the opportunity to speak. My name is Michael Payton. I'm a retired Navy SEAL. I spent 22 years in active duty, multiple combat tours, master breacher, lead breacher, and I've had multiple TBIs, multiple concussions. I've actually been knocked out because of explosions. Long story short, I support the bill because I've actually gone through the HBOT therapy and have had sustained gains from it. So consistent sustained gains, and I support it. That's all I got to say.
Thank you for your testimony, and thank you also for your service. Okay, we have a motion and a second to report, unless there's any other questions, we have a motion and a second to report and refer SB 1082 to Finance. So we'll open the vote to do that.
Mr. Chairman, members of the committee, thank you very much. Have a great day.
Ayes 15, no 0.
Thank you. Okay, is Senator Boysko, is she here? Okay. I see him. Yeah, she's got another committee. Yeah.
Senator, Mr. Chairman and members of the committee, first I have a technical amendment, line amendment for 1279 on line 66.
Is there a motion or a second for that amendment? Second. Okay.
Thank you.
You want to explain the amendment or?
Well, it's just a simple, they just left out the word be between shall and construed. So it's a technical
Okay. So
amendment.
all in favor of adopting the amendment will say aye.
Aye.
Any opposed? Okay, why don't you continue, Senator?
Thank you, Mr. Chairman. So we know there's a difference between prescription glasses and over-the-counter readers. We now I now have a bill that will comply with the federal government dealing with hearing aids and over-the-counter hearing aids. And this is an administration bill. In October of 2022, the federal law took place that will allow over-the-counter sale for air-conducting hearing aids without a license. And this clarifies that the licensure by the Board of Hearing Aid Specialists and Opticians is not required for a corporation, a partnership, a trust, association, or other like organizations engaged in businesses of selling prescription hearing aids defined in the bill as hearing aids that is not a hearing aid that is not an over-the-counter hearing aid, provided that it employs only licensed practitioners in the direct sale and fitting of prescription hearing aids. So basically, to make it very simple, The federal government has changed policy and said that we have over-the-counter hearing aids that we can buy at Target and Rite Aid and Walgreens to just conform our policy to the new federal policy. I'm carrying this bill. I have Mitch Mellis from DPOR and Jennifer Sy. I'm here to answer any questions, but I think this is pretty self-explanatory.
Okay, could we have either one of the representatives of the administration come forward briefly? Just want to check. There's no need for a medical professional to do this. It can be done, as the senator explained, without in an over-the-counter manner.
Mr. Chair, yes, Mitch Mellis, Agency Director for DPOR. That is correct. Equivalent to how people use readers that they buy at CVS, what the federal government did is essentially divide up and say certain, under a prescription care, you have to have a prescription and go and see an audiologist and have it prescribed. Otherwise, you can go to the counter and purchase your own without a physician or a prescription involved.
Thank you. Are there questions for Senator Boysko or for the administration? Okay. Hearing none, are there others in the room who would like to speak against this legislation? Anyone in the room else who would like to weigh in favor? Is there any speaker in Zoom?
Those in Zoom who wish to speak on this bill, please raise your hand electronically. There are no speakers, Mr. Chairman.
Second.
Okay, there's a motion and a second to report Senate Bill 1279. All in favor will vote aye on the electronic voting board.
Ayes 15, no 0.
Thank you, Mr. Chair.
Thank you. Now we've got some other senators waiting to present, and Senator Marsden, I know, is doing the Energy Subcommittee, so I'm going to ask him to bring forward, I believe you have one bill that you wanted to strike, which was 1543. Is that right?
That is correct, sir.
Okay. First, we need do we need a motion to do that, to strike 1543?
Move it to strike Senate Bill 1543.
Okay. So all in favor of removing that bill from our future docket will vote aye.
Ayes 15, no 0.
Okay, and now we're on, is it 1351, I believe, is your other bill?
Yes, sir.
Okay.
And I believe we have a substitute we need to.
Okay, all in favor of adopting the substitute that's been moved and seconded will say aye.
Aye.
Any opposed? Okay. So the substitute is now before us. If you'd like to explain that for us.
Yes, thank you. Thank you very much, Mr. Chairman. This bill deals with adjusting the percentage of certain local and regional meetings that can be held virtually from 25 to 50% if every year they state the policy as to how many virtual meetings there's going to be, and it also guarantees public comment. Now, the most important thing to know here is this only applies to regional and local advisory boards. It does not apply to the General Assembly, local elected bodies like city councils or boards or supervisors or school boards, planning commissions, boards of architectural review, or boards of zoning appeals. It's more about Campbell County's Litter and Environmental Commission, Hampton's Athletic Hall of Fame Committee. You get the idea. But what it's here to do, Mr. Chairman, is to encourage more people to get involved who, a lot of the folks who get involved in these committees and commissions are a little older. It's more convenient. It helps folks who are disabled to be able to participate. And I think it's a minor change to things that could have a big difference for these boards that are more a little bit more informal. And I think that it's a critical thing to do to improve the attendance and the participation of democracy.
Thank you. Can I ask the clerk, the substitute, were there substantive changes between that and the original legislation? What were the, or it's online now, but okay. You want to give us an overview?
Sure. So the original bill, I think this cuts out a lot of the additional language that didn't apply to local or regional public bodies. And so now it's just this language on line 76 through 78 of the substitute, so that it's narrowed to local or regional public bodies. And it does not convene an all-virtual public meeting more than 50% of the meetings held per calendar year, rounded up to the next whole number. And I believe that was a response to the House version that didn't go as well in subcommittee.
Thank you. Okay. So first, if there are any in the room who would like to speak against this legislation, please come forward.
Ask a question, Mr. Chairman.
Yeah. Why don't I have Senator Mason ask your question first? Yeah.
I saw in the paragraph above, you keep public bodies of what we've talked about, no more than 25%, no more than 2. So we've talked about that the last couple of years, trying to figure out how to wrestle with this. And in the off-season, whatever commission you're on, we've adopted no more than 2 times a year, no more than 25%. You want to go to 50%?
For these limited local and regional boards, not for, anything involving elected folks and appointed boards and that kind of thing, just for the, the community boards, like the Athletic Hall of Fame board, the things in the community that you want people to really get involved in and participate in. We think it would improve attendance and involvement in the meetings and interest in the topic at hand, because let's face it, the world has changed since the pandemic in terms of what people's expectations are, and I think this moves a little bit towards where people are these days.
Thank you, Mr. Hammond. Thank you, John.
Okay, we were going to take testimony first, those in opposition.
Thank you, Mr. Chairman, and members of the committee. I'm Megan Ryan with the Virginia Coalition for Open Government, and I just want to give some background here, and that for the past 3 years, we have, this legislature has steadily increased the opportunities for people to participate remotely, either as individuals or as a body. And what we did last year in a compromise bill that we worked on with the Press Association and the Municipal League and the Association of Counties, we said, let's standardize these rules. Let's make the rules apply to everyone. And in doing so, we got rid of this tiered system that used to say only state agencies could meet all virtually and local bodies can't ever. So we standardized this and we said everybody's going to apply by the same rules. And so here we are this year. The trade-off of expanding this was saying, well, there's got to be some limit on the number of times you can do this, because in-person meetings are by far preferable. So when we got here, that's where we were last year, and now here we are today saying, no, let's expand this to 50%, and again, create a tiered system where some people can do it more often than others. And I understand that this is limited to advisory bodies and regional bodies, but I want to make clear regional bodies are including things like regional jail authorities or transportation authorities, people who are making huge decisions that impact a lot of Virginians. As far as local advisory boards, the whole reason for these local advisory boards are to advise the local body. So they too have a great deal of influence on the local body that has created them. And finally, I just would like to reiterate the point that FOIA is not a bill about encouraging people to be on boards. FOIA is a bill that guarantees the public the opportunity to witness the operation of government. If you want to encourage membership in these boards, change the laws that relate to the appointment of those boards. Don't change the laws of a bill to guarantee public access to their government in order to encourage that participation. Thank you.
Thank you. Okay, any others against the bill in the room? Others who'd like to speak for this legislation, please come forward and identify yourself.
Good afternoon, Mr. Chairman, members of the committee. I'm David Blunt. I'm with the Virginia Association of Planning District Commissions. First, I want to thank you all for what you did last year. You put into place a framework that allows certain local and regional bodies to have all virtual meetings. I think this is just a modest change to that, and giving some more flexibility for some of these bodies to have some additional flexibility to hold more meetings virtually. I can tell you at the PDC level, there are a number of transportation committees, other advisory bodies, and when all virtual meetings were the norm, as they were for much of the past 2 years or so, saw a lot of increased participation, both by members of those bodies actually being able to participate where it maybe had been a challenge for them to gather in person, but also by members of the public. And at that level, those discussions that they're having on particular programs or projects, they're often seeking to involve as many people in the public as possible. So definitely saw the benefit of doing that. So I would urge you on behalf of the PDCs to make this modest change and just to allow a little bit more flexibility for those advisory bodies at both the regional and the local level to be able to conduct business. Thank you.
Thank you.
Good afternoon, Sarah Taylor with the City of Alexandria, here in support of this bill. Co-sign everything that David said, but pointing out that this really is about these local advisory bodies. This is about your tree commission, your commission on women. It's about the Prince William Animal Advisory Committee and the Committee on Aging. This is about the Hampton Athletic Hall of Fame Committee and the Citizens Unity Commission. These are about people who want to be engaged in their community and need to be afforded as many opportunities as they can to do that. And especially when you're talking about seniors, when you're talking about people with disabilities. In my free time, I serve on one of these local advisory bodies that deals with issues related to disabilities, and every single one of the members of our body technically has a personal exemption from being there in person and could be virtual. But because of the limitations on our ability to hold virtual meetings, we have to decide amongst ourselves who is the most disabled, who is the most inconvenienced, who is the most at risk, who can participate virtually and who can be there in person. And this additional flexibility would really allow bodies like that to meet in a way that is both productive and allows people to participate, but also allows them to do the work that they need to do, and always includes opportunities for public engagement outside of the body. So we appreciate your consideration and hope you'll support the measure.
Thank you. Welcome.
Thank you, Mr. Chair. Phyllis Rico with the Association of Counties, and we support this bill.
Thank you. Okay, are there speakers in Zoom on this bill?
Those in Zoom who wish to speak on this bill, please raise your hand electronically. We have one speaker, Mr. Chairman.
Okay, why don't we let's hear their testimony.
Tanya Milling, please unmute your mic and give your testimony.
Hi, yes, Tanya Milling, the ARC of Virginia. We thank the Senator for bringing this forward. As others have said, this opens access to people with disabilities. We've learned so much about that through COVID, and so we very much support this bill. Thank you.
Are there members of the committee with any further questions before we take any motions? Okay.
Move to report.
There's a motion to report and a second. All in favor will vote aye on the electronic voting system.
Ayes 10, noes 5.
Okay, thank you, Senator Marston. Okay, now before we hear from the other senators, I just want to mention 3 bills that have been requested to go by for the day. Those include Senate Bill 1115, 1176, and 1087. Do we need a motion to do that? Or, okay, there's a motion and a second. Take those 3 bills by for the day. All in favor will say aye. Aye. Any opposed? Okay, those bills are by for the day. Next in the sign-up list, I have Senator Hackworth.
Thank you, Mr. Chair, members of the committee. Senate Bill 1263 is a recommendation from the construction industry to reduce unnecessary regulatory burdens and to provide accountability for actions taken to halt residential, commercial, and industrial construction. And what it does, it adds section 36-114.1 that allows an individual builder or developer the ability to recover court costs from the locality that issued the stop work order in the event the court rules in their favor that the work order was unnecessary. And this is the underlying tone is for localities to know that if a stop work order is issued, it needs to be for a good reason, or they would have liability if that was overturned. So under current law, recovery of damages are very limited and hard to prove. And this bill would allow, in those instances, that the contractor or developer, whatever, take this to court and they win their appeal, that they would be able to recover their court costs. It does not short circuit any of the appeal process, but only if it is found to be unnecessary work order, stop work order.
Thank you, Senator. Are there others here today who'd like to speak for this legislation, SB 1263, in the room? Anyone in the room would like to speak against SB 1263? Anyone in Zoom here to testify?
Those in Zoom who wish to speak on this bill, please raise your hand electronically. There are no speakers, Mr. Chairman.
Second.
Okay. There's a motion and a second to report SB 1263. All in favor will vote aye.
Ayes 14, no 0, 1 abstention.
Thank you, Mr. Chair, members of the committee.
Okay. We have a gaming subcommittee report, and I know there's some folks in the room who are waiting on those bills, so we're going to take those up from Senator McPike.
Thank you, Mr. Chairman. The Gaming Subcommittee met, considered several bills. First off, we considered Senate Bill 836 from Senator Reeves. It sets up the Problem Gaming Treatment Support Advisory Committee and really starts to focus on the problem gaming and prevention. It did have a recommendation of reporting at 8-0 from the subcommittee, and I so move.
Okay, there's a motion and a second. You took testimony in subcommittee?
That's correct.
Okay, so since testimony was taken in subcommittee, we won't be taking additional testimony at this time. All in favor would, unless there are questions for Senator McPike, we'll vote. All in favor will vote aye.
Ayes 15, no 0.
Okay, and what's your next?
Thank you, Mr. Chairman. The next bill was Senate Bill 1195 from Senator Reeves. It establishes a gaming regulatory fund for the purpose of making sure, essentially, that the Virginia Lottery has separated funds for the different lines of businesses they have. And so this is a bill that would set up the process of setting a deposit area for licensing fees, renewals and transfers, and the rest of it in order to keep the different funds from commingling, Mr. Chairman. And that bill has a recommendation to report of 8-0, and it also is required to go to Finance and move to report and re-refer to Finance.
Okay, there's a motion and a second. Were there any questions for Senator McPike before we vote? Okay, all in favor will vote aye.
Ayes 15, no 0.
Thank you, Mr. Chairman. The next bill is Senate Bill 1209, and I believe Senator Reeves, you have an amendment. You want to speak to that and move the amendment.
Okay, there's a motion and a second for the amendment in the nature of a substitute. Is that correct? Okay. All in favor of adopting the amendment in the nature of a substitute will say aye.
Aye.
Any opposed? Okay.
Thank you, Mr. Chairman. Real briefly, we caught an error when we originally passed it. We needed to put limitations on how many days the four conventions could last. Otherwise, they could an organization could theoretically operate year-round. So we limited those to 7 days for a convention for each of those four, and that's the amendment, Mr. Chairman.
Okay, so sets a motion for the amendment. Is there a second for the amendment?
Second. Yes,
this is an amendment to the amendment in the nature of a substitute, or you're explaining what we just adopted?
Just explaining what.
Oh, I'm sorry. Okay. So are there any questions for Senator McPike or for Senator Reeves?
So,
Okay.
as a summary, Senator Reeves has been working, I think, diligently over the last year with Delegate Krizik and many others to create some compromise and get folks back in sort of good standing and doing some fixes from legislation that, last year. And I think this gets us a long way, and therefore move to report and re-refer to finance.
Okay, there's a motion and a second to re-report this to finance. All in favor will vote aye.
Ayes 15, no zero.
Next, Mr. Chairman, we had Senate Bill 1212 regarding the Virginia Racing Commission. Provides for basically the onset is basically a number of machines per day is one of the main elements. And Senator Reeves, you want to touch base on some of the other key provisions. As you might recall, over the last couple years, we've been wrestling with the Horse Racing Commission and the number of days actually raced. And so this ties and does time a number of gaming machines to a number of days.
Thank you, Mr. Chairman. What this does is when we decided to give HHR or parimutuel betting the ability to have electronic gaming, we tied those to race days. Just make sure that they apply that. We also have, I think it's an amendment in the nature of a substitute that we need to get before the body, and I so move.
Second.
Okay, all in favor of adopting the amendment in the nature of a substitute will say aye.
Aye.
Any opposed? Okay, it's before us. And is there additional explanation or comments? No?
Yep.
Okay.
Recommended from the gaming sub with a vote of 8-0, and so move.
Okay, all in favor will vote aye.
Ayes 15, no zero.
Okay.
And lastly, Mr. Chairman, Senate Bill 1235 from Senator Obenshain, and I believe we have also a substitute available of that one, and so move.
Okay, there's a substitute. All in favor of the substitute will say aye.
Aye. And Mr. Chairman, Senator Reeves has agreed to explain, since we have a substitute for Senator Obenshain, since he's over in Judiciary. Senator Reeves.
Before Senator Reeves speaks, I just want to be clear. This was reported without a recommendation from subcommittee. Is the amendment in the nature of a substitute what you had considered, or is that since?
Mr. Chairman, it is since that subcommittee, we had several questions during subcommittee that we're not able to resolve, and we asked them to work it out. And since then, Senator Reeves, as well as Openchain and other partners, have worked out that, and so that's why we have had the recommendation of reporting with no recommendation until it was resolved, and it is the idea that this substitute now fixes those things.
Okay, Senator Reeves.
Thank you, Mr. Chairman and Chairman McPike. What we had to do was we were worried, this is, if you all remember, we were worried about if certain organizations did $40,000 and less, and that there was an opportunity to expand that and just let it proliferate again. And so what we had to do was we worked with Mr. Menifee over at VDAC, obtained the language to do that, where they have to obtain a permit pursuant to the provisions of 18.2, 340.25, and some other provisions that Mr. Menifee had come up with to make sure that they could actually have the opportunity to do what they were trying to do. And basically the problem was we tightened it pretty tight. It caused some issues in some of our localities in Southwest, Southside that had maybe done one raffle a year. A museum does a raffle a year, and that's the only fundraising they had, and they couldn't do it under the type provisions we had before. So we're allowing them the opportunity to do it with some very narrow guardrails, and if we need Mr. Menifee to explain the thought process behind that, he's here to do that. I don't know that we need to do that, but I'm comfortable with it.
Okay, are there questions for Senator Reeves or for Mr. Menifee from the members of the committee? Okay. If there are no questions, is there a motion?
Mr. Chairman, I move to report and re-refer to the substitute to finance.
Okay, the motion is to report and re-refer to finance. All in favor of SB 1235 will vote aye.
Ayes 15, no zero.
And Mr. Chairman, that concludes our report. We'll have a subcommittee tomorrow afternoon to take up the remaining gaming legislation. Thank you.
Thank you. Okay, we have Senator Peake is next in the queue to be followed by Senators Hanger and Suderline on deck.
Thank you, Mr. Chairman, members of the committee. This is Senate Bill 988, and this is a bill I brought to add in another exclusion to the Virginia Consumer Protection Act. Full disclosure, this came to me as a result of my law practice. The last year, I've seen a couple of lawsuits, just standard breach of contracts, one of them for home repairs with the general contractor, and they bring a suit, alleged claim for breach of Virginia Consumer Protection Act. And now I've got one currently that involves, it was a sale of a home from a private individual to another private individual. They allege account for Virginia Consumer Protection Act. We did run this by the Ethics Committee. This law is not retroactive, so it has no effect on that case that is pending. But the courts have ruled that, well, they're going to let that go under the Virginia Consumer Protection Act. And if you look at the act, the intent of the act is to promote fair and ethical standards for dealings between suppliers and the consuming public. And then if you go down and look at what they say supplier, it means solicits or engages in consumer transactions, plural. And if you look at the Consumer Act.
Mr. Chairman, I believe there might be a substitute.
I do have yes, thank you.
I move the substitute.
There's a motion second to adopt the substitute. All in favor will say aye.
Aye.
Any opposed? Okay, the substitute's before us, Senator.
Thank you, Mr. Chairman, Senator McPike, for reminding me. And as we made it very simple when I first brought it, the Virginia Poverty Law Center, I believe, came to talk to me about the wording, and the Office of the Attorney General came to talk to me about the wording. And so I think we've now got it in agreement with both people. And this is just to exclude the sale of a private residence to another private individual. It does not apply to home builders, home manufacturers, but it is just not, and the important thing to look at under exclusions, F, real estate licensees who are licensed under the chapter, they're excluded. So the realtor is excluded, but the actual home seller who's selling their own private residence is not excluded. So they're trying to bring them under suppliers of homes, which they're not. They're not building the homes. They're selling their own private residence to another private individual, and that's who this would apply to. And
yes, Senator Stewart.
Thank you, Mr. Chairman. Senator Peake, how did a court determine that a private individual is a supplier?
I filed a demur, Mr. Chairman. Senator Stewart, yes, filed a demur to it, alleging exactly that. They're not a supplier of homes. They aren't engaged in transactions. He overruled the demur, so currently that case is still pending and subject to a jury trial, subject to treble damages, subject to attorney's fees for a private individual. The act clearly is not intended to apply to that. Since a judge made a bad ruling, I'm following the leads of Senator Surville, Peterson, and Stanley, and thought I would bring an amendment to the to fix the code so it won't be misunderstood again.
Does that clarify?
Well,
or do you have further question?
My only concern, Mr. Chairman, is that the code is very clear today, and if we have one judge who makes a bad decision, I haven't seen the substitute yet or the line amendment or whatever it is, but I always have concerns about changing a perfectly clear law because of one bad decision.
Mr. Chairman?
Yes, continue.
And I will say that they're using it, all the plaintiffs' attorneys are using it in all kinds of construction contracts now. So they're taking any type of construction contract, alleging a claim of a violation of the Consumer Protection Act, and the courts have been letting it go. There are numerous cases out there, circuit court opinions letting it go.
Mr. Chairman.
Senator Stewart.
Isn't a contractor supplier as defined in the Consumer Protection Act?
Yeah, but these are not these are not in the contractor supplying of materials as it should be, but these are in home repair. So they're doing home repair. So an electrician, welder, not supplying materials.
But with all due respect, that was a large part of why the Consumer Protection Act was created, I think, is because you had people out there who were misrepresenting the materials, misrepresenting the work, and I think clearly they are suppliers. But the issue of if I sell my house to you without a broker, that's not a supplier.
Well, under what Some judges, Mr. Chairman, some judges are interpreting that to be. That, I think, is very clear as well. And then talking with other defense attorneys, they are seeing an abuse of the Consumer Protection Act, and I think we need to broaden these. And there is some protection for others that are covered under other laws, like the real estate agent. So agent's protected, but a private home seller is not.
Thanks. Okay.
It would be G. It would be, they're A through F right now. This would add G.
It numbers the components that were lettered, and it adds residential home sales, and lastly, it refers to contractors. Why are contractors in there rather than just the home sales?
Let me see.
Yeah, you need to.
That might have, that's one that I thought we would.
Yeah.
Yeah,
I think-
withdraw 8. 8 should not be in line 8.
Okay, so I'll entertain an amendment to remove line 32 from the bill.
Second.
Okay, all in favor, we'll say aye.
Aye.
Okay, so now we have it referring only to residential home sales.
And on line 7, I would strike owners, private, and put sellers was the final. Residential home sales between natural persons involving the seller's private residence where the seller is not engaged in the business of selling homes. And that was to comply with the Attorney General's recommendations.
Okay, so we have another amendment to the amendment in the nature of a substitute on line 30 to switch out the word owners for the word sellers. All in favor? There's a motion and a second, and all in favor will say aye. Okay, so now I think we have it the way you intended it.
Yes.
Okay, is there further discussion from members of the committee? Okay. This is on line 30.
Well, number 7.
Referring to number 7, yeah.
Thank you, Mr. Chairman.
Okay.
It's probably a nit, but line 7 still says : contractors.
7.
Up at the top of the bill, not number 7, line 7.
Yes,
sir.
line 7.
I mean, it.
Oh, I see.
Yes,
This is in the
strike,
title
yes.
of the amendment. Is that another
Yeah.
change needed?
Strike that's
Okay.
just a description.
So moved.
Yeah.
Okay, motion second, just correct the title. All in favor will say aye. Aye, okay.
Mr. Chairman?
Yes, Senator Bell.
Question, this, on item 7, tell me if I'm reading this right. So if it's a real estate agent and they're selling a home they own, this exclusion would apply if it's the home they're living in as their residence, but it wouldn't apply if they were to sell another home that they own for, say, a rental property.
Well, real estate agents are excluded under F. So real estate licensees are already excluded. So if you were, and which was line 29, real estate licensees who are licensed, they're excluded already.
Okay, are there members of the public in the room who would like to speak against this legislation?
Mr. Chairman,
Senator Hashmi.
before we go there, then I'm just confused if Senator, if real estate licensees are excluded in line 29, it seems to me that there's a contradiction then in line 31. It says where the seller is not engaged in the business of selling homes. Isn't that a contradiction then?
Mr. Chair, no, because we're talking about the private individual. So we're excluding the private individual who is selling their home. So it actually, if the private individual is a realtor, then I guess they're double excluded, but not
Mr. Chairman.
inconsistent.
Senator Stewart.
I think you're trying to exclude builders there. You're trying to say the sale of, if I didn't build the home or something like that, I think is what they're getting at with that language.
Mr. Chairman, I guess that was my confusion for my question. Sorry, Mr. Chairman. Maybe we could reword that because, I mean, the way this is now, I almost take it selling homes as a realtor versus building homes, what Senator Stewart just said. Is there another way we could word that? Because it does seem, if we look at item 6 and item 7, the wording, it seems a little repetitive and confusing.
Well,
Mr. Chairman.
Well, I'm going to let Senator Peak answer, and then we'll go to Senator Stewart.
Realtors are excluded, no matter what they're doing. Realtors, the realtor industry, the real estate industry, any realtors are excluded from violations of the Virginia Consumer Protection Act. However, if one individual is selling the house that they've lived in for 30 years to another individual, under current court ruling, they're considered suppliers of homes. Even though they didn't build it and they're only selling one home, they're considered a supplier, plural. And they're engaged in transactions. It's one transaction. So that's the purpose of this. It is not, and that's why we've gone through natural persons, so it's not a company that builds homes. So that's why we put that language in. And it was private individuals, sellers of a private residence. So it can't be, to address your prior question, it can't be a rental place because it's not their private residence. So it's got to be a natural person in their private residence to another private individual.
Okay,
it's very, very specific.
Senator Stewart, did you have a further question?
Mr. Chairman, I was just going to comment that I think Senator Bell's right. I understand what they were trying to do, but it is confusing. And I think all you have to say is residential home sales between natural persons involving the seller's private residence, period.
And that, Mr. Chairman, that's very close to what I started with before it got changed by two other parties. And I'm happy to accept that because each person that looks at it comes up with different wording. But I love Senator Stewart's wording. And I would consider that a friendly amendment.
Okay, so that's a motion from Senator Stewart, seconded by Senator Bell, to trim it further. So it will read residential home sales between natural persons involving the seller's private residence, period, on line 30.
Because apparently residential home sales between private parties, those 7 words, 1, 2, 3, 4, 6, 7, were much too confusing. So now we've ended up with this. I tried to make it as simple and straightforward as I could.
Okay. I think was there a member of the public waiting to comment on this bill? Why don't you come forward?
Thank you, Mr. Chair. Richard Schweiker, I'm Chief of the Attorney General's Consumer Protection Section. Appreciate Senator Peak working with us on this language. As he mentioned at the beginning, our office, as well as the Virginia Poverty Law Center, had looked at the bill. We don't have a position on the bill. We agree with the interpretation we agree with the stated interpretation of the act that an individual sale like this is not supposed to be covered by the act due to the existing definition of supplier and the use of the plural with regard to consumer transactions. The specific language in that last clause, it gets a little complicated when you're trying to think of everything you don't want to exclude here. So we wanted to avoid, we recognize real estate licensees are already excluded, but you could have developers, builders, et cetera, who are selling homes. You could also have an individual who is essentially in the business of flipping homes and has multiple homes that they're working on selling to the property, and one of those could be considered their residence. So that's why we have the language in there that says where the seller is not engaged in the business of selling homes. So again,
preferred it with the language that we were just removed.
Correct, to try to capture everything we can think of, recognizing we're trying to address a situation that we think shouldn't be a problem, but due to a few circuit court decisions, we understand the senator's concern.
Okay. In light of that, if anyone wants to, does that change your position on the wording, Senator Peak? Do you?
I think Senator Stewart's, I believe Senator Stewart's wording was consistent with that. Was it?
Well, why don't we take this by temporarily, and if you could talk to the gentleman from the Attorney General's office and maybe just run that by Senator Stewart to see if we could
have Senator Stewart's wording for me so I can.
I think it's the same language without where the seller is not engaged in the business of selling homes, which we're just trying to capture by that wording someone who is not a real estate licensee, who has multiple properties. They're selling them to the public. They happen to have one that they consider their residence. So in their course of their business of selling, building, et cetera, homes, they take that one home and they sell it. And we think that that person is situated differently if they're in the business of selling homes to people, which would be more like what we consider a supplier to be, as someone who's in the business and engaging in consumer transactions. So that's our suggestion, and we'll defer to the
Mr. Chairman
and the senator what they want to do.
Senator Bell.
I guess my question is, I hear what you're saying about the home flipper. I think that it's another complication. How many homes does somebody have to sell to be considered engaged in the business of selling homes?
More than one. It'd be transactions, and that's in a flipper. It wouldn't be their private residence, or if it is, so it'd be
Could
more than one.
Hey, Mr. Chairman.
Yes.
So the guy in my town moves his family into a house, fixes it up, spiffs it up, makes it look great, sells it. Moves into another one, moves his family into the other one, spiffs it up, makes it look great, sells it. Complete. And that, to me, is what he's trying to get at, right? Because it's his private residence, but he's in the business of selling homes.
Mr. Chair, that could be another example. We're looking more at where they could have multiple properties, and one of them they choose to live in while they're working on multiple properties. So that's a situation. But I think heard our comments, and we'll defer to the patron and the committee. Again, just trying to capture everything. It's a challenge when you're trying to deal with something that you think the statute already addresses, but they understand the situation with the ruling. There isn't anything in the statute that says what's the magic number for how many transactions. It's just something that, as you can imagine, would be subject to reasonable interpretation.
Well, Mr. Chairman and Senator Mason, so if that's the case, then that's going to be the hearing in front of the judge. So you're going to put on the evidence, and the evidence is going to be, well, this guy sold 4 homes in the last 3 years, and the judge is going to make a determination. I think he's engaged in the business of selling homes. Therefore, I'm finding that he comes under this. He's going to look at another one. This guy sold 1 home in 30 years. I don't think they come under the Virginia. As in all statutes and as in all laws we pass, a judge has to make a determination. This just makes it clear for the judge that if that guy sold 1 house, so that couple sold their family residence they've been in for 15 years, they're not violating the Consumer Protection Act. They shouldn't be subject to treble damages, and they shouldn't be subject to attorney's fees. If they're sold 4 or 5 homes in the last 5 years, the judge's probably going to come to the opposite conclusion. And that's what happens on all of these. They're going to have to interpret our language. They always do. We can't come up with a clause that is not interpretable. So I'm trying to do the best I can.
Okay. We have the amended language currently before the committee. Is there?
Mr. Chairman?
Yeah, it reads now on line 30 of the substitute. It excludes residential home sales between natural persons involving the seller's private residence, period.
Are you ready for a motion?
We'll entertain a motion.
Move to report.
Okay, so the motion is second to report the amendment in nature substitute as amended and amended and amended. All in favor will vote aye.
All right.
Any opposed vote no. Okay. Oh, did I
Thank
Ayes
you, Mr.
12,
Chairman,
noes 2,
members of the
2
committee.
abstentions.
Such a clean language, 5 or 6 words, nothing to it. Thank
you.
all.
Thank you for that simple bill. Okay, next in the queue is Senator Hanger.
Thank you, Mr. Chairman and members of the committee. I have Senate Bill 1305, and I have a substitute, amendment in nature substitute that I'd like for you to adopt.
Okay. All in favor of adopting the amendment in nature substitute will say aye. Any opposed will say no. Okay, the amendment is before us, Senator.
Thank you, Mr. Chairman, members of the committee. And Mr. Chairman, this substitute is like 3 paragraphs, not like the 70 pages I put down this morning, because you'd have to wait an hour for your bill to be heard. So we will get to this. This deals with farm buildings and structures which typically are exempt from the building code. And as you're aware, and we talked about this a bit last year with some of the issues, and we weren't able to resolve some of those issues. So what we ended up doing last year was creating an agricultural building technical advisory committee, if you will, where stakeholders engaged to try to come up with some recommendations for this year for some things that we could do. And what the bill that you have in front of you in the nature of a substitute does essentially four things that are in agreement. And there may be individuals here that would like for us to go further, but that's what the reason why we're going to continue, as one of our recommendations, we continue this advisory committee in order to try to address them. As an example, I think there's some type of farm building which is unique now that some folks would like for us to address, and I think we can address that within this and come up with a recommendation within the technical advisory committee. But what we do have, I think, broad agreement on now is the fact that for these types of buildings, we're very fortunate with the growth of agritourism, particularly events at weddings and what have you, and what were used to be barns. They're still barns, but we have events there. Wine, the wine industry, a lot of events going on there. But the three provisions that we would put in place right now is the need for portable fire extinguishers for fire suppression. That was agreed upon. And a simple written plan in case of an emergency for exit, which would not be a plan that comes under the Uniform Statewide Building Code, but rather just a simple emergency plan for exit. And then a sign posted in a conspicuous place that basically says this building is exempt from the building code, but alerts individuals to be aware where the emergency exits are and that type of thing, a simple sign. The first pass at the sign before it was agreed upon was to say, if you notice this building shaking, getting out of here in a hurry before it falls down. But we came up with something more refined now, and it's just simply, most of these structures are safe, but there are instances because of the fact that they are on in areas where we're farming and they're used for farm use, but we're inviting the public in sometimes for relatively large events at some of these wineries and also for weddings and that type of venue. So that's the bill, Mr. Chairman, and there are people here that can speak to it if needed.
Okay. Anyone here like to testify about the need for the bill? Briefly, but please introduce yourself.
Thank you, Mr. Chairman. Martha Moore, Virginia Farm Bureau. We appreciate the leadership of the Senator, and we are in support of the bill.
Thank you. Anyone else in the room who would like to speak for or against this legislation? Okay, anyone in Zoom waiting to testify?
And I would say, Mr. Chairman, that like local governments and fire departments have an interest in this type of legislation, and I think they're comfortable with the direction we're headed.
Excellent. Okay, so here a motion and a second to report Senate Bill 1305, amendment in the nature of a substitute. All in favor will vote aye.
Ayes 14, no 0.
And, do I have Senator Barker's proxy or is it Senator Bell? Oh, we give Senator Bell. You've got his proxy for.
He didn't proxy out at all.
Oh, I'm sorry. I'm looking at the wrong one. Okay, thank you. Okay, next up we've got. Thank you, Senator. Senator Suderline. And maybe someone could call courts and tell Senator Edwards that he would be up when he comes over.
What's that? Well, good news.
Okay, good. Okay. Okay. Senator Suderline, welcome. Which bill do you have?
Senate Bill 1026.
This is dealing with the Consumer Protection Act on data.
Yes, it's the children's online privacy provisions. I've got a substitute, which is basically a series of line amendments, just adding it, and I'd ask council to share that with you.
Okay, that's a substitute or line amendments?
It's a substitute because it's a series of the same line amendment over and over again.
Okay, there's a motion to adopt and a second. Is there a second for that amendment in the, okay, motion and second. So all in favor of adopting the amendment in the nature of a substitute will say aye. Aye. Any opposed? Okay, that is before us.
Thank you, Mr. Chairman. So Senate Bill 1026 seeks to protect children's online privacy. We have the Consumer Data Protection Act, and this makes it so that in that act, children aren't defined as people 13 and under. They're defined as 18 and under, like they are so many other places. The Commonwealth has regularly taken the position that we protect minors. In the case of alcohol sales and tobacco sales, it's even at 21, not 18. And I think that teenagers under 18 also deserve the protection of their privacy online. This legislation would ban the knowing processing of personal data for children for the purposes of targeted advertising, sale of personal data, or profiling purposes. I think there'd be no question if we were talking about this in a physical space, everyone would find it objectionable that if when your 14-year-old went into a store, they were monitored the whole time. It made note of what products they looked at. Then when they walked down the aisle and looked at something a little longer, that was recorded. Then when they left there and they went down the street to another store, it was continued to be monitored. And then that data was sold later to someone else to advertise to your child. But that's what we're talking about in the online space and what we're trying to prevent. I understand that there are advertisers that would like to be able to advertise to them, and I think you're going to hear from some folks that will give different reasons why they don't want to have to stop advertising to these young people. I think that it's a very serious issue that we protect the online privacy of these young people so that these things cannot continue.
Okay, and what would you say if there was a 17-year-old who gives their birth date to either the movie theater or a frozen yogurt store and gets a free yogurt on their birthday and that data is then captured? You would want them to have to get their parents to authorize that, or?
I don't want them selling that data to anyone else.
Would they be able to take that data and retain it in the database under your bill?
I believe that they would be able to know that, but I don't think it's a big issue about the parental consent because we already have that in other places. And I think there's some folks here from both the administration and the Office of the Attorney General that'd be happy to speak to some of that.
Okay. There's a question from Senator Stewart. We adopted a substitute. Is that now loaded online? Okay, yeah, it should be in your computer. It just came up on mine, but
and Mr. Chairman,
yeah.
I would just tell the senator and the committee and anyone watching that the substitute, what it does is in 12 places where it previously had the word operator, each time it changes to controller and processor, or controller or processor, depending on what would make sense with the syntax of that sentence.
Mr. Chair.
That's it.
Senator Hashmi.
If I could ask the senator a couple of questions. I just want some clarification. The bill states in the amended language here that in section A, section, can't read my small screen here, 59.1-577.1 operator responsibilities, that the operator shall obtain verifiable parental consent prior to registering any child with the operator's product or service. How exactly would that happen, if you could clarify the procedural or implementation processes?
Yeah, I'd like to let Jesse Lynch with the administration answer very specifically for that as how it looks elsewhere.
Good morning, or good afternoon, Mr. Chairman. Jesse Lynch on behalf of Governor Youngkin. So already, if you are compliant with the COPPA law at the federal level, the Children's Online Privacy Act, you would have a way to achieve verifiable parental consent, and the FTC regulates what those methods could be. And so they have other methods that we don't include in this bill, but the ones that we pull from are ones that would be verifiable consent under that 1998 Act at the federal level.
And can I ask you, we're deleting some language about controllers and processors that comply with the verifiable parental consent requirements of the Children's Online Privacy Act shall be deemed compliant with any obligation to obtain parental consent under this chapter. That was language that was existing that we're eliminating. Is that restated elsewhere, or what did that mean?
Mr. Chairman, that language was already in the Consumer Data Protection Act. So the bill that this committee passed in 2021 had language that said if you are compliant with the Children's Online Protection Act, that you are compliant for the form of verifiable parental consent. And so we thought to be able to change the age requirement from 13 to 18, we had to decouple from the federal standard.
Mr. Chair.
Right
here.
Oh, yes, Senator Rouse.
Thank you, Mr. Chair. Question, why go from 13 to 18 and not necessarily 13 to 16 when teenagers are of driving age and they're able to operate a vehicle? Then why wouldn't they be able to operate online? I'm just curious about why.
Yes, sir. Mr. Chairman, Senator Rouse. So I believe, as the senator stated, the policy of the administration is that child means child. And so we wanted to make sure that we were encompassing and protecting as much information as possible. So once you become an adult, you can do what you want, but we wanted to make sure that a minor was all protected in this bill.
Under this, Senator Rouse, why don't you continue?
Mr. Chair, thank you. But would you submit that a 16-year-old who has a driver's license to operate a vehicle can necessarily maintain their or be responsible with the internet as well?
Mr. Chairman, Senator Rouse, it's not, in the administration's position, it's not about being responsible. It's about the protections that are being given to them at this point. So they would have all the other things that are banned. We've seen some of this come up in the teenage depression stats that we see. Those are most linked with the time that the child's online, and that's actually that high school age. And so I think that's one of the areas that we most want to protect.
Mr. Chairman.
Senator Hashmi.
I'm sorry, I was not finished quite with my questions. I heard an answer, but I don't think I really heard an answer. How does this get implemented? How does this? How do we obtain verifiable parental consent prior to the registration of any of these products or services?
Sure. So, Mr. Chairman, Senator Hashmi, you would have to have a method for doing this. Like I said, those companies that are compliant with the current federal law should have those methods already in place to be able to do. Very similar to if you run ads on Facebook right now on a political campaign, you would have to have a form to verify that you are who you say you are.
It looks like that requires either a credit card, a debit card, or an online payment system or government-issued ID. Is that correct?
Mr. Chairman, that's correct.
So if I'm sorry to interrupt, but if a child wants to sign up for get a free yogurt on your birthday or movie theater multiple purchase club, their parent has to provide a credit card or something?
Mr. Chairman, if it was being processed and operated online, yes. I mean, it wouldn't apply to the yogurt shop in that situation before if you were putting up but you're not selling that data. So that's the difference.
If they want to sell
So only if the data is sold?
Mr. Chairman, yes.
Or targeted for advertising.
Senator Hashmi, I interrupted you. Did you have further questions?
No, Mr. Chairman, thank you.
Okay. Senator Mason.
Thank you, Mr. Chairman. So I'm just trying to track how this works, same as Senator Hosky. So my 14-year-old just bought something online last week. It came to Taylor Mason. I opened it because I thought it was to Taylor Mason. Turns out she bought it. At what point were they to verify she's under 18? How do they know that it had not? Now, it turns out my wife monitors the credit card, so she knew about the transaction. I'm fairly certain she didn't give permission for the transaction. And to your point, we like to protect the fact that she likes brown sweaters for some reason from being sold. But I'm just trying to figure out, I mean, I think the concept makes sense, but how you implement this in the online transactional world, I'm struggling to follow.
So they already intended for 12-year-olds.
So, Mr. Chairman, Senator Mason, if she had logged onto your account and she had purchased something, and maybe the Attorney General get there, but there's an actual knowledge standard in the Consumer Data Protection Act already. So that would be, it would be for the form of creating an account for her, let's say, that she would be using that you would have to ban that her purchases, what you look at on her Amazon account wouldn't be tracked and then sold.
But, Mr. Chairman,
Yes,
she did not. She did it on her own. She's a smart little 14-year-old spending some cash money. How do we know she's under 18? How does the, and maybe I'm just missing what you're trying to do, but.
So, Mr. Chairman, Senator Mason, if she's logged onto your account, that wouldn't be covered under this. And, I mean, whatever data was collected, if all of a sudden you started to get certain advertisements because of what she searched, that wouldn't be covered under this. It would be if she had her own account as a 16-year-old using your credit card. She could do that, but then the information wouldn't be shared in that way.
Are there further?
Mr. Chairman?
Yes, Senator Bell.
Okay, let me throw one at you and tell me if this would apply or not. If my granddaughter gets on YouTube and she likes the Disney Collector website, which she does, and it's boring, I don't know why she likes it, but if she likes that and she hits the subscribe button, and then there's a cookie on there, and probably other things will come as a result of that cookie being dropped, and the person who has that channel makes money because of the number of viewers they have, and some of them are very popular and they make quite a bit of money from that. Would that apply here? Because in essence, they are disclosing information on that account that hit the subscription. And they're making money from the fact that they have that channel with subscriptions and ads.
Mr. Chairman, Senator Bell, the view count, I would be unsure, and maybe the Attorney General's office could answer, but for the purposes of putting more cookies onto the computer for that account, for the account linked to her if she was registered under the age of, and her birthday was certified, there would be no more, at least the sale, the profiling, the creating of a profile to follow her with different things that she likes, that would be banned under this.
Mr. Chairman, follow up?
Yes, Senator.
So how would we police that? I mean, would there be special software or things for people in Virginia? So how would that be policed in the Commonwealth?
Mr. Chairman, Senator Bell, so currently the enforcement power sits at the Attorney General's office for this. Other states have different ways to do it. Some have private causes of action. The bill you passed in 2021 gives that enforcement authority to the Attorney General. I would just state that there is a 30-day cure period. So if there was a violation, the Attorney General found that, they would get in touch with the company. They would say, we found these different things that are wrong. You have 30 days to comply. And at that point, I believe it's a $7,500 fine for every time that you did something wrong. But that's in the current statute. We haven't changed the enforcement mechanisms.
Mr. Chairman, one final question.
Yes, Senator Bell.
Okay, I'm getting the enforcement. I probably didn't ask that question very well. Is there technology that can prevent this from happening, or will we just take action if it does happen?
Mr. Chairman, Senator Bell, so other countries will have different dates. So if you're a large corporation, you would already be doing this for, let's say, folks under the age of 16 in some European countries for different mechanisms. So the utility, or I'm sorry, not the utility, the company themselves would be supposed to be in compliance with the law. It would be on their side. It's not directed to the consumer.
Okay. Thank you. Before we go to Senator Stewart, does the Attorney General's office want to comment on just to clarify any of this?
Sure. Thank you, Mr. Chair. Again, Richard Schweiker, Chief of the Attorney General's Consumer Protection Section. We do have the exclusive enforcement authority under this statute, and I would just confirm what was said with regard to how enforcement works, because this statute is very different from all our other consumer protection statutes with regard to this enforcement mechanism that was described. So very different from the Consumer Protection Act, which we just discussed. Under that statute, we can give notice and we can sue. We give notice, an opportunity to settle, and we can sue. Under this statute, it requires that we give notice and an opportunity to cure, and if the situation is cured or fixed, addressed, we cannot sue. Somebody violated the law, If they fix it in that time period, then there's no enforcement. It's only after, if they continue a violation or they breach an agreement that we reached in connection with investigating a possible violation, can we sue. And then if we do sue, then the remedy is injunctive relief, civil penalties. Of course, civil penalties are awarded in the discretion of the court. Another thing to keep in mind, and I'll say the Attorney General's office does support the legislation, to keep in mind is that there is this federal COPPA law out there. And while you referenced the provision that was removed, COPPA has a section that provides that a state can't impose liability that's inconsistent with COPPA. So to the extent, so we view this statute as it has some additional requirements, but not inconsistent with COPPA. And if someone is complying with COPPA, at least with regard to any overlap, we can't impose liability, which I've already described to you. The only liability under the statute is, one, we notify somebody that they've committed a violation, we give them an opportunity to cure, and it's only if they don't address it. Or in what may happen as well is in a situation where we give notice of violation, the business, the person comes forward and they may explain why it wasn't a violation. There are some other provisions in here related to not knowingly processing data too, so there's some other protections there as well. And I guess one more thing to be responsive to how we would go about this. Our office doesn't have software that we would be going out and checking this. It would be more consistent with if there's a privacy issue raised with our office, a complaint, we would assign an investigator or a dispute resolution specialist to look into it, notify the business, try to reach a resolution, and if there's still a problem, then we would send that notification giving the right to cure. So it would be really dependent on the public bringing issues to our attention.
Mr. Chairman?
Senator Bell.
I think you make an interesting point there. Can you tell us, have you been getting requests from people for these type of issues?
So, Mr. Chair, the law just went into effect January 1. So we periodically get complaints about consumer privacy issues. In the absence of a statute like this, we've addressed those issues under our existing Consumer Protection Act, which is really just to oversimplify, it's basically a deception statute. So if there's been deception or misrepresentations about a business's privacy policies, that would be that's what would trigger it. So the short answer is it's new. We've started getting complaints this year. Some of them we're evaluating because they're actually about things that occurred prior to the January 1 effective date. Thank you.
Are there other questions from Senator Stewart?
Thank you, Mr. Chairman. I'm just trying to understand. We've spent a lot of time talking about how we would implement this, and I don't know. I don't know how to do that, but I'm confident that the internet providers would know how to do it. But help me understand this, because as I think about it, if I have an account and I agree to those terms, I am of the age of majority and I can consent, and so I can be bound by that contractual obligation, and they can sell my data or whatever they want to do because I've agreed to it, right? But if you are under the age of consent, i.e. less than 18, how do they agree to start with? And so does the law just overlook that? Or, I mean, I get where you're going. You want to keep them from targeting these kids because there are millions of billions of dollars made on doing that. But how is it that they can target them now when they are not of the age of consent to authorize it?
Mr. Chairman, Senator Stewart, so we're governed by that federal law that has all those protections that start at 13. And so, to my knowledge, that's the only law that says anything about what can be done with that child's data, at least at the federal level. And they're 13, and they end at 13. They don't start. So, right now, it only applies to anyone under the age of 13. So, a 12-year-old's data is not supposed to be knowingly sold without verifiable consent, sold, processed, and made for profiling purposes. But this bill would increase that to 18, so it would provide protection to all minors. Does that
so, Mr. Chairman,
answer your question?
Senator Stewart.
So is that the genesis of the bill? All we're doing is changing the age from 13 to 18.
Mr. Chairman, Senator Stewart, that's correct. There's been movement, not a lot, at the federal level to raise that age in some way. I will say for the record, it is bipartisan in both the House and the Senate. Unfortunately, the last Congress has not taken anything up about that. But Virginia already has an existing legal mechanism, and that's what we're trying to use.
All right, so, Mr. Chairman.
Senator Stewart.
So are they able to implement this at below 13 currently?
Mr. Chairman, Senator Stewart, if they were not implementing, it would be my understanding that they would be breaking federal law, and they'd be in front of the Federal Trade Commission.
So, Mr. Chairman, then I guess we all assume that they are implementing this for kids under 13. So they could easily implement it for kids under 18.
Mr. Chairman, Senator Stewart, that's correct. There's different ages in different countries too, if that helps.
Okay.
All right, Mr. Chairman, can I try
Senator
one more
Bell.
time?
I'm sorry, Senator Mason.
Oh, sorry. Okay, so my 14-year-old daughter sets up an account with Lululemon, the most overpriced stuff in the history of the free world. She goes and buys that brown shirt I just told you about. They ship it to she pays. They ship it to my house. There is nowhere in that transaction that they ask what your age is. You're just making an online transaction. They have no idea how old my daughter is. Now, Lululemon, smart enough to get her email address and fires her marketing material every day to spend more money on this overpriced stuff. And Lululemon's competition starts sending catalogs to my house in her name. Are they not in violation of what you are trying to set up?
Mr. Chairman, Senator Mason, so in that form, at that point, she has provided, I assume at that point, a credit card or a debit card or something, in which case they have complied in that way. They assume that she is, for virtue of having a credit card or a debit card, 18 years old, or that someone at 18 years old has gotten her that card. And so
They're not knowingly doing it.
they're not knowingly going through and processing this. They have enough information to be able to use and to say that, yes, you can process this data in the way that's still consistent with this act.
Mr. Chairman, and the only way you'd know is if I complained to the Attorney General. You have absolutely no way of tracking what we're talking about. No one does, right?
Mr. Chairman, Senator Mason, that's the current law. If you had any violation of Consumer Data Protection Act, your real way is you do not have a private cause of action from the bill you passed and the committee passed in 2021. If the child was 12 instead of 14, that's still the method you would want to use.
Thank you, sir. Thank you, gentlemen. Thank you, Mr.
Okay. I think we should hear from the public, particularly the technology community, if there are any witnesses who'd like to speak for or against this bill. Why don't we start with those who are for this legislation? If you could come forward and be brief, if there's any others in the room. Okay. Any in the room who would like to speak against or have any concerns with the legislation?
Good afternoon, Chairman Evans, Senator Suderline, and members of the committee. My name is Margaret Durkin, and I serve as Executive Director for the Mid-Atlantic at TechNet. TechNet is a trade association, and we represent over 5 million employees in the e-commerce, IT, and data spaces. TechNet and its members strive to provide an age-appropriate and safe environment for young people online. And we wholeheartedly agree that keeping children online is a top priority. However, we have some concerns about this approach. First and foremost, as Mr. Schweiker noted, the Virginia data privacy law just went into effect on January 1. That law provides many provisions for teens, including opt-out of targeted advertising, as well as the sale of data. We would advise the committee to let the Virginia Omnibus Privacy Bill work before deploying new requirements for companies that already have mechanisms to address these issues. The idea of data collection was also brought up. This bill would require additional data collection of sensitive data, such as those government-issued IDs or other payment methods. I understand that many people don't want to give more data than necessary, so that's another reason why we would advocate against the bill. It also takes a one-size-fits-all approach. Senator Rouse talked about a 16-year-old who is able to drive but would need parental consent to make routine purchases. This bill doesn't account for developmental differences between, say, a 14-year-old and that 17-year-old. And under this bill, that 17-year-old would need parental consent to stream their favorite music online. TechNet would recommend that this bill go to the Joint Commission on Technology and Science, as they already have a consumer data work group that could work on this issue. Again, we acknowledge the importance of keeping children's data safe online. However, we advise a consistent, thoughtful approach and simply let the Virginia data privacy bill work, at least for a period of time, before making additional changes. Thank you, and I'm happy to take any questions.
Thank you, Ms. Durkin. Before we get to, I have one question I want to start with, which is if you could just restate the point about streaming music. What's the potential adverse impact you mentioned, or complication?
Sure, no adverse impact for the actual streaming of music, but the point I was making is that, as Senator Rouse indicated, someone who is responsible enough to know how to drive, or perhaps is preparing to vote when they turn 18, would require parental consent just to stream music. So that's where we're talking about that one-size-fits-all approach doesn't really work here, because it doesn't account for those age differences.
Thank you. Senator Stewart?
Thank you, Mr. Chairman. I'm just curious with the witness, because I really am trying to understand this bill. This bill is more geared towards gathering and selling young people's data, I think. And that's what we're trying to address. So explain to me how a provider or person in your trade association can now legally gather and sell a 14-year-old's data when they are not of the age to consent to that, as I am, because I'm over 18, and I agree to your terms when I use your site or whatever. How is it that you can do that now with a 14-year-old when they can't consent?
Sure. As to the specifics of that data collection and sale, I don't have an answer on that now, but under the Virginia privacy law that went into effect on January 1 of this year, those under the age of 18 can opt out and have the ability to opt out of the sale of their data and targeted advertising. But in terms of the mechanisms for data collection, I would have to get back to you and the committee on that.
Mr. Chairman.
Yes, Senators, continue.
And I don't care about the mechanics or the implementation. That's not what concerns me. But what I want to understand is, under the law, how is it that you can collect a child's data and sell it when that child can't authorize you to do it because they're not of the age of consent under the law? As I am, because I'm over 18 and I can consent and I can agree to the terms of your site. So how legally can you collect and sell their data when they can't give you permission? It would require their parents to give you permission anyway.
At this time, I don't have an answer to that, but I can get back to you.
Thank you.
Thank you.
Okay. Were there others waiting to testify? Yes.
Thank you.
Thank you.
Good afternoon, Chairman, members of the committee. My name is Amy Boss. I'm the Director of State and Federal Affairs at NetChoice. NetChoice is a trade association of leading Internet businesses. Our mission is to make the Internet safe and for free enterprise and free expression. While we support and share the patron's goal to better protect children's privacy, we ask you not to advance SB 1026, as it would actually put teenagers at significant risk of identity theft, fraud, and undermine the growth of those seeking access to college. As written, the bill would require parental consent for any collection of data from 14 to 17-year-olds, which means just about every single website would require a parent to consent every time their child visits that website. This would create delays and impediments to routine purchases or internet services used by teens unless a parent is present to verify each time. SB 1026 does not say how a business can or should determine the age of potential registrants. Children can easily skirt non-intrusive verification techniques. For example, check the box if you're over 18. Therefore, in order to be in compliance, businesses would likely have to collect more information from all consumers to determine consumers' age, running contrary to the patron's stated goal of protecting privacy online. As we know, the internet perfect identification is nearly impossible. Our banks and financial institutions have struggled for years with this and continue to struggle today. Just this holiday season, we were inundated with warnings from banks about fraudulent financial payments via the bank's own system, Zelle. Likewise, the IRS, the Virginia Department of Taxation, suffer from fraudulent tax filings every year. The unfortunate truth is that identifying the end user is nearly impossible. A way to mitigate these problems is to collect multiple identifiers of the end user every time they access a website. This would include social security cards, driver's license, passports, activating the user's camera to validate who they are. Instead of taking this approach, a better approach is underway in Virginia with HB 1391, which creates a commission to investigate ways to address challenges faced by teenagers, or HB 1575, which mandates digital citizenship in schools and empowers teenagers with information to keep themselves safe and secure online. As mentioned, the Virginia Consumer Data Privacy Act just took effect weeks ago. We would also encourage the committee to let this new law take effect. There are significant protections for teens, including for teens to know what personal identification is collected about them and to correct, delete, or port this information. We would also encourage the committee, at the very least, to send the bill to the Joint Commission on Technology and Science for further review. Thank you again for your time and consideration, and happy to answer any questions.
Ms. Boss, I have one question about if you have a child like my niece is 17 and applying to colleges, if she wanted to just go onto a website and sign up and request information from a college or university and they wanted to retain that information, would this bill require the parent to give a credit card or something to authorize that?
That is our understanding.
Thank you. Okay, next speaker.
Mr. Chairman.
Senator.
Could I ask
Senator
the witness a question?
Yeah. What's exempt? Colleges, okay.
Mr. Chair, may I ask that past witness a question?
Yes, Senator Stewart.
I'm really not trying to be difficult. I just want to understand this. The same question that I asked the other witness, if a person is under the age of 18 and they are not of the age of consent, how do you now legally collect the data of a 14 or 15-year-old and then sell it without getting their parents' consent?
Yeah, I don't mean to be difficult. I know that I can't speak for our member companies. They may have slightly different techniques that they use, but I'd be happy to get back to you in a written response on that.
Mr. Chairman?
Senator Stewart.
Again, I'm not interested in how you physically do it or the process. My question is under the law. If a child is not able to give consent because they're under 18, which I understand is what the law is in the whole country, how do you gather and sell that data and do it legally if they can't give you consent without the parent's permission?
I will bring that question to our companies, how they gather and sell that data under current law.
Thank you.
Welcome.
Mr. Chairman, Rob Bohannon here representing the Northern Virginia Technology Council. Nothing new to add. I think the other speakers covered that. But we wanted to also say certainly support protecting children online, but think this law is a little bit too much too soon. We have the new law that just went into place and has some significant protections for that sensitive data for children. Thanks.
Thank you. Senator Stewart.
I really want to understand, Rob. Can you answer that question?
Unfortunately, Senator Stewart, I cannot. I don't know. I know that, again, the current law has the options for people to delete, correct, opt out of data, but I don't know about sort of your specific question now. Sorry.
Mr. Chairman.
Thank you.
Senator Mason.
So just speaking to that question, I think Senator Stewart is giving us the impression that you pull up something and has this long page of here are the terms and conditions that at the bottom you click I agree. And so it seems like your question is if you're under 18, how the heck do you do that today? Well, they don't. Those things don't exist. Every website we're talking about making transactions and sales is about the fewest number of clicks, not getting terms and conditions on everything you do. So the vision that you're putting forth, that there's some document that someone under 18 agrees to in these circumstances, just isn't there.
Thank you, Senator. Senator Suderline.
Yeah, to close,
I wish that getting a driver's license in Virginia was the way that Senator Rouse characterized it, because that would have meant that 16-year-old David Suderline got his driver's license at 16 years old. But when I was in high school, I chose to go somewhere else after school and didn't get back till about 1 a.m. And my parents then informed me that I would not be getting my driver's licenses 3 months later when I became eligible, and I got to wait to 17. Since then, Senator Barker and Senator Smith, my predecessor, made it so that, and Senator Smith thinks these are great things, and I was not as sympathetic to what you all did, but made it so that you have to be 16 and a half to get a license. But even then, you can't go get the license if you're under 18 without parental consent. And it's not simply parental consent checking a box. The parent has to certify that you've driven at least 45 hours, 15 out of those have been after sunset. And as we've discussed so much ad nauseum to me about actually giving the driver's license to the child if it's someone under 18, and if that has to happen at the courthouse or not. The Commonwealth does not entrust folks under 18 years old with a driver's license without parental consent and without repeated parental consent throughout the entire process. We regularly say 18 is where we define a child, and then in some places like tobacco and alcohol, that's been defined upward to 21. So I think we're very clear that 18 should mean 18, with the exception, though, we're going to allow internet advertisers to advertise knowingly and sell the data of minors. So I hope it will be the pleasure of the body to advance the bill, and if there's any concerns about the timeline, I'm happy to delay enactment until January 1st of next year.
We've had quite a lot of discussion, but I just want to give anyone who is waiting to testify on Zoom a chance to comment briefly.
Mr. Chairman, could I ask one question?
Senator Bell, why don't you ask your question? Yes.
My question on the exemption of the institution of higher learning, I see on the definition that they're included there, but I'm looking in the exceptions section, I didn't see it. Can you point me to what line that is?
Yeah, this is a fun one to go through all the lines. Yeah, I might ask counsel.
The current exemption for institutions of higher education, Mr. Chairman and Senator, is in the statute, Title 59.1, Section 576, subsection B, subdivision Little Romanet 5.
We have great
but it's
attorneys.
not in the bill.
Certainly do. Okay. Was there anyone waiting to testify via Zoom on this bill?
We have one speaker, Mr. Chairman. Kara Binder, you unmute your mic and give your testimony.
Hi, good afternoon. Thank you for the opportunity to speak today. My name is Kara Binder. I'm State Policy Director at the Computer and Communications Industry Association. CCIA is an international not-for-profit trade association representing a broad cross-section of communications and technology firms. CCIA strongly believes that younger users deserve an enhanced level of security and privacy online. However, we caution against several provisions that are included in this bill. I won't belabor this too much because I think the witnesses that have previously spoken did a really good job outlining some of our shared concerns. However, I'd like to stress the final point that was made about different developmental ages, and raising this, requiring this additional consent, I think would especially impact users who are in the higher end of that age range. If you think of a 17-year-old who's potentially, going on for higher education purposes off to college or university and have not yet hit that 18-year-old mark, I think this would really have really wide-ranging impacts for those users, especially as they might be located in a physical location away from a parent who might not be able to provide that type of verification. I would also stress the previous points that were made about allowing the current Virginia omnibus privacy law to go into effect and examine the impacts of how that law is in practice. In addition to raising some of the concerns regarding the verifiable parental consent mechanisms that were highlighted in the bill. These could potentially conflict with data minimization principles and other consumer data privacy protection measures. Again, I thank you for the opportunity to speak today.
Thank you. Okay, the bill is before the committee.
Mr. Chairman,
Senator Mason.
although Senator Suderline wins the award of saying parental consent the most times in one paragraph, I would like to move that we do pass this bill by indefinite with a letter to the Joint Commission on Science and Technology to study this important matter. And I am worried about how it works to figure out how we can make the process that he's trying to get at work.
Is there a second? Second. Okay, it's been moved and state the substitute motion.
Second.
Okay, so the motion before us now is to report SB 1026. All in favor will vote aye on the electronic voting system.
Ayes 6, noes 9.
Okay, so we'll return to the original motion, which was to PBI with a letter to the Joint Commission on Technology and Science for review.
Could it be a straight PBI instead of going to the commission where?
I'd like to see it go to a commission where it's
Yeah, I
analyzed
know
carefully.
why industry likes that. I'd rather not go to the commission.
Okay, well, with the motion before us is to PBI with a letter to analyze this subject. So all in favor of PBI with a letter will vote aye. Okay.
Ayes 10, noes 5.
Thank you for your presentation. Senator Morrissey has been waiting with Senate Bill 1227, I believe.
Good afternoon, Mr. Chair, members of the committee.
And do you have a
substitute
today?
Yes, and I would move that substitute.
Well, as a member of the committee, you can't, but I can. So I'll make the motion. Is there a second? Okay. So all in favor of adopting the substitute, say aye. Aye. Any opposed? Okay, so we do have the substitute before us. Is that online now, Council? Okay, why don't you start explaining it while it comes up?
Certainly. Mr. Chair, let me preface my remarks by saying that this bill is a narrower version than my SB 409 that passed this committee and the state Senate unanimously last year. And if you want me at a later time to get into the details of the amendments, I'll do that as well. This bill revises current law regarding occupational licensure for people that have a criminal record. The purpose of this bill is to ensure that those citizens that have a criminal record get a second chance when they're trying to get an occupational license. As we all know, one of the key factors in a person who comes out of jail or prison is meaningful employment. It's the key ingredient to making sure that they're not a recidivist. And often these individuals that have a criminal record navigate the hurdles of trying to get a job. Here in the General Assembly, we regularly reevaluate existing laws to ensure that people that have a prior criminal record do get that second chance. And so our current occupational licensing laws present that opportunity, but this bill goes a little bit further. In Virginia, we do not bar people from getting an occupational license because they have a criminal record, but we can improve upon it, and we can make sure that we can streamline the application process. So there's 4 things that this bill does. It ensures that occupational licensing boards do not deny an applicant access to a licensed profession because of an old, non-sexual misdemeanor, if the person has remained completely crime-free for 3 years after that offense. Number 2, it focuses on the rehabilitation of that individual, as opposed to, oh, you have a prior criminal conviction, you're out. We're not giving you that license. It looks at what they've done to rehabilitate themselves. The board can consider rehabilitation-related factors, not just that they haven't gotten in any further trouble, but what steps have you taken to become purposeful and productive citizen? One of those things might be when they're in jail. What did you do when you were in there to prepare yourself when you get out to be successful? Third thing is it requires the Department of Professional and Occupational Regulation to regularly report data points related to applicants with a criminal record. And lastly, it ensures that individuals denied a licensure due to a prior criminal record are informed of that offense's relationship to the denial. So that's the gist of the bill, Mr. Chairman, and if you want me to go deeper into the weeds, I will. I remind the body that it did pass here unanimously in the Senate, but in the other House there was some consternation, so it's a narrower bill.
Okay. Are there members of the committee with questions for Senator Morrissey? Are there members of the public who would like to testify in support of this legislation? Welcome.
Good afternoon. My name is David Jimenez, and I'm here on behalf of Prison Fellowship, the nation's largest Christian nonprofit serving prisoners, former prisoners, and their families, and a provider of prison programming at over 5 prisons in Virginia, including Fluvanna as well as St. Bride's. SB 1227 is a common sense measure that would strengthen Virginia's current laws on occupational licensing to promote second chance hiring and meet labor shortages in the state. DPOR does a very good job right now in terms of allowing for careful, individualized review of applicants with a criminal record to foster access to work while also keeping in mind public safety and workplace safety. And this bill would in many ways codify, strengthen, and streamline those best practices. So we strongly urge support, and I'm happy to answer any questions.
Thank you. Others, why don't you come forward and identify yourself?
I'm John Shenholz, the president and co-founder of the McShin Foundation. We support this bill.
Thank you. Anyone else either in support or against the bill in the room today? Are there witnesses in Zoom waiting to testify?
Those in Zoom who wish to speak on this bill, please raise your hand electronically. There are no speakers, Mr. Chairman.
Okay. There's a motion and a second to report SB 1227, an amendment in the nature of a substitute. All in favor will vote aye on the electronic voting board.
Ayes 14, no 0, 1 abstention.
Thank you, Senator Morrissey. Thank you. Okay, I know that Senator Edwards is not present, but I understand there's someone in the room who was going to tell us about his SB 1081. Hi. And I understand there's a substitute, so first we'll take a motion to, okay, it's been moved and seconded that we adopt the amendment in the nature of substitute for SB 1081. Council, can I get a copy of that? Okay. All in favor will say aye. Aye. Any opposed? Oh, it's just online. Okay. Okay. Why don't you explain to us the bill and particularly any changes, significant changes in the substitute?
Sure. Good afternoon, Mr. Chairman, members of the committee. Eric Reynolds, Director of the Office of the Children's Ombudsman. I appreciate Senator Edwards' introduction of this bill to sort of fix some of the, it's a cleanup and clarification type of bill. What I understand when the statutes that were created 2 years ago, I understand that they took a lot of language from Michigan Office of the Children's Ombudsman, and so some of the language was not consistent with how we do things here in Virginia. And so much of this bill, I would say 90% of this bill, is to clarify and clean up some of the language so it's consistent with existing Virginia law in Title 63.2, Social Services, as well as Title 16.1, the Juvenile Domestic Relations Court statutes. And so most of this cleanup is to clarify and to make sure our language is consistent with existing statutes. There are a couple of substantive provisions here. I think there's a clarification, first of all, with regard to the Freedom of Information Act. Currently, our statutes say all our records are confidential, and we wanted to ensure and clarify that they are exempt from FOIA requests, and that is to protect the identity and the information from complainants that contact us for assistance, as well as the agencies that we investigate. So we had originally, in the original bill as introduced, we were going to exempt the entire office from FOIA. We did receive some information from the Coalition for Open Government. They had some concerns, and so we worked with them to clean up the language. And so the substitute cleans that up and clarifies that all information, documents, records related to our complaints, complainants, and investigations, that's what's exempt from FOIA. So as far as internal policies, procedures, procurement, all that falls under other statutes and not necessarily exempt from FOIA. The other substantive, the main substantive thing, change from the bill introduced as to the substitute came from the Attorney General's office, and that was to clarify that we have the authority to investigate children's residential facilities in addition to local departments of social services and licensed child placing agencies. The original statutes mentioned children's residential facilities, but didn't tell us what we could do with them. So we're clarifying that that authority is there. And so that is most of the bill and why we're asking, why I'd asked Senator Edwards to introduce this.
Thank you for the description. Are there questions for the witness? Okay. Are there others who'd like to speak for or against this bill in the room today? Okay. Anyone waiting on Zoom to speak? I guess we'll wait for. Okay. Okay. Any other questions from members of the panel or motions?
Move to report. Second.
Okay. Moved and seconded that Senate Bill 1081 be reported. All in favor will vote aye on the electronic voting system.
Ayes 15, no 0.
Thank you for your presentation.
Thank you, Mr. Chairman. Thank you, committee.
Okay, and I know Senator Ruff had at least one bill.
Thank you, Mr. Chairman. Senate Bill 1108. We do have one big amendment, thanks to Senator McPike, to take the word safe out on line 203.
Okay, the amendment has been moved and seconded. All in favor will say aye.
Aye.
Any opposed? Okay, the amendment's passed and the bill is before us.
This legislation adds a new section to that portion of the code that deals under the Consumer Protection Act with such things as CBD oil. The new issue is kratom, which is derived from a plant in Southeast Asia. This has been used for many, many years, particularly in that part of the world. As with anything that is not registered by oversight, there are those that would either dilute it for greater profit or enhance it with greater elements which may or may not be safe. The goal is to subject kratom to the standards that assure that it is safe to use if it is sold or produced in Virginia. These are the conditions. Nothing can be added to the kratom that could harm the consumer. It cannot be sold if it exceeds the federal standards or if it includes synthetic compounds. It cannot be sold to anyone under the age of 18. Additionally, it must have labeling that includes any additives or recommended dosages. There are folks who would like to speak to it, but if you want to see if there's any opposition.
I think we can start by asking if there is anyone opposed to this piece of legislation. First, we'll take the opponents. None in the room. Okay, those who are here for the bill, if you could let us know who you represent and why you're for it, that'd be great.
Mr. Chairman, members of the committee, Matt Bentke with the American Kratom Association. The bill is pretty simple. We're seeking to protect people from the products that are currently out there right now. I've never had a better show and tell than this right here. And this is
from here.
well, I'm going to give it to everybody on the side, and it's all it says is K-Shot. That's it. This product is sold in CBD stores. It is sold in gas stations. It's sold everywhere. That's all it says. It doesn't say what's in it. It doesn't have directions for use, safe use, and 12-year-old kids can go in and buy this. Now, kratom is a safe product. You could drink 7 or 8 of these. You're going to throw up. You're not going to have a good morning. It's not going to hurt you, but this is what we're trying to prevent. So I've got some very high-level folks behind me. I'm going to give this to each end, but this is what we're trying to protect people from. Yes.
Thank you.
Thank you.
Mr. Chairman, members of the committee, my name is Mac Haddo, Senior Fellow in Public Policy with the American Kratom Association. We are a Virginia nonprofit corporation, but we represent 12 to 15 million Americans who use kratom across the United States. As was stated earlier, it is a plant that is grown and been used safely for 2 centuries in Southeast Asia, came to the United States, and today there are 12 to 15 million Americans who use it safely. Our problem is adulterated products. You will hear reports about adverse events and deaths that are the result of kratom that is not manufactured properly and doesn't meet the standards that are required for safe use. And we ask that you would help with this particular legislation because it will effectively protect consumers. The average kratom consumer in the United States today is you and I. It is 25 to 55 is the average user. The National Institute on Drug Abuse says it is a harm reduction tool because some use it in order to wean off of opioids, but most use it like you would a replacement for a cup of coffee. Increased energy, increased focus. Some use it to relieve anxiety symptoms. This legislation is critical to protect consumers because it needs to be properly labeled and regulated in the state of Virginia. Thank you.
Thank you.
John Shenholzer, President and co-founder of McShin, but more important, I'm a person in long-term recovery from substance use disorders. I've been clean and sober over 40 years and very active in our community. That's why I'm here. I'm here as an advocate, not as a consultant. And a few years back, I provided technical assistance to a local sober house who cycled 30 acute detox and opiate addicts from heroin and fentanyl. And the only product they had to help alleviate the pain associated with the withdrawal symptom from the opiate was over-the-counter kratom, a home remedy. 29 of those 30 successfully detoxed in a 5-day taper. One of the fellows run off, went back to his girlfriend. But the point is, in the recovery community, I see the benefits far outweigh anything that may not be a benefit. So this needs to be protected. This protection bill is a very good bill, and I support it.
Thank you for your testimony.
Thank you.
Hello.
Thank you, Mr. Chairman. My name is David Reynolds Darian. I'm the owner and CEO of Botanaway, Inc. We're a dietary supplement manufacturer that works with this ingredient, as in many others. I was born with an extra lumbar vertebrae, heavily overprescribed opiates my whole childhood. Found this plant and have been able to be now 14 years free from my addiction. My business is all about sharing that experience, and I think that kratom should remain available and properly labeled here in the state of Virginia. Thank you for your time. David Darian, Botanaway, Inc.
Thank you.
Mr. Chairman, I'm Jack Henningfield. I'm a scientist, the science guy of neuropharmacology by training and experience, and published about 500 articles in my first half century, and looking forward to the next half century. I develop medicines and I consult on drug regulation, food dietary regulation, including to the American Kratom Association. My opinions are the same as what I've published, and many come out of scientific think tanks that I convene. I love working with other scientists worldwide. My experience most relevant maybe was at the National Institute on Drug Abuse, where I headed clinical pharmacology and development of treatments for addiction during the 80s and 90s. And what we've learned there was the need for diverse paths away from opioids and other drugs. What we found in kratom is one such way, and that's why NIDA, my former institute, is funding lots of research, tens of millions of dollars of research, led by Dr. Nora Volkol, who talked about this at a meeting last December. So what have we learned? The first most simple, basic lesson with all of this research is relevant to your bill. Nature got it right. When we look at kratom, the constituents, the effects in animals, in humans, in clinical studies, in laboratory studies, the natural product, whether it's used in the leaf form or derivatives, but kept clean and pure and not adulterated, such as extracts, is remarkably safe and remarkably without serious adverse effect. The main adverse effect is, frankly, a great one from a safety perspective. You feel nauseated, you might, to be blunt, puke. And that keeps people from using too much. And the other thing that we find, contrary to all of the addictive drugs that I've studied, people don't use kratom to get wasted. They use kratom to perform better during the day, to increase their focus, to monitor, help with their mood, more like people use caffeinated products and other substances, not the way people use opioids. But having said opioids, this is where it gets really serious and why I'm here. Kratom is a lifeline and path away from opioids for many, many people across the nation. There is no federal survey that shows that it is a gateway to opioid use. There's lots of data and surveys showing that it is a path away from opioid use. So if you're looking for any of the science, I'd be happy to provide it. If I don't have it, I know who's got it. And if it's not there, I'll let you know it's not there. But I urge you to consider this because there are millions of kratom users across the country, but tens of thousands in Virginia, many of them using it as a path away from opioids. If they buy dog food, they know their dog is getting products that's safe and regulated. They should have the same opportunity for kratom. Thank you.
Thank you. Okay, were there any in Zoom waiting to testify on this particular bill?
Those in Zoom who wish to speak on this bill, please raise your hand electronically. There are no speakers, Mr. Chairman.
Okay, there's a motion and a second to report SB 1108. All in favor will vote aye.
Ayes 15, no 0.
Okay, thank you, Senator. Now, Senator Vogel, you had two bills.
I do, Mr. Chair. I'm going to start with, let me just send a text really quickly to the folks who need to be here. Okay, I'm going to start with first Senate bill, hold on. I'm going to start with Senate Bill 1368, Mr. Chair.
Okay, we'll direct our attention to 1368.
I'm stalling just a second.
Dealing with CSBs and health insurance coverage.
Yes, thank you, Mr. Chair. As you know, Mr. Chair and members of the committee, we've had a really difficult time with recruitment and retention of our health professionals. And this came to me at the request of our CSBs, and the goal was to try to alleviate some of the pressure on them by treating them like state employees just for purposes of inclusion in the state health plan. So that's what this bill would do. It's pretty simple and pretty straightforward. And with that, I would just ask that the members of the committee consider the bill.
And so the operative language is line 305, allowing employees of community service boards to participate in the insurance plan?
Mm-hmm.
Okay. Are there...
It changes the definition for just that part of the code, calling them a state employee just for purposes of allowing them to be eligible.
Okay. Are there questions for Senator Vogel?
Mr. Chairman.
Senator Mason.
And do all CSBs serve more than one locale?
No, this would only be available to those that are multi-jurisdictional CSBs. So it would be limited to those. What was your question?
Well, both of mine, Mr. Chairman.
Go ahead.
Both of mine serve multiple jurisdictions.
Yes, so both of yours would qualify.
But there are some that just serve one jurisdiction, and
Correct.
they would not.
They would not. That's correct, Mr. Chair.
Can you
Thank you.
explain the reason for the distinction? Is it the multi-jurisdictional that have a different challenge?
I might need some help from somebody who wants to speak to that.
I'd be happy to help.
Yes, would you be willing? Can I phone a friend? Thank you.
Mr. Chair, members of the committee, my name is Jim McGrath. I'm the Executive Director of Rappahannock Rapidan Community Services Board. We are a multi-jurisdictional community service board serving Culpeper, Fauquier, Orange, Madison, and Rappahannock County. Our board serves a largely rural area and employs approximately 400 employees. I'd be happy to answer the question. There are 40 community service boards in Virginia. Of those 40 community service boards, I think 16 of them are single jurisdiction community service boards, predominantly Fairfax, Alexandria, the bigger metropolitan areas, where those community service boards are actually parts of local government. So those employees are employees of the counties. In our rural communities, such as ours, when community service boards were founded, multi-jurisdictional community service boards were created. And we are neither state employees nor are we employees of the local municipality. As such, because we are part of neither, health insurance is a very large challenge for organizations like ours because we have so few covered lives. In December, if I can make some additional comments, Mr. Chair.
Please.
In December, Governor Youngkin announced his plan to transform Virginia behavioral health care. I applaud the Right Help, Right Now plan and its 6 pillars. Pillar 5 of the governor's plan states, we must make the behavioral health workforce a priority, particularly in underserved communities. It is precisely the underserved communities that are predominantly served by our multi-jurisdictional community service boards, and until we make sustainable and systemic changes to our system, we will just continue the rhetoric of wanting to make a difference and ending up spinning our wheels with little traction. Multi-jurisdictional community service board employees are neither state nor local employees. Due to their relatively small number of covered lives, health insurance costs to employees are high and volatile from one year to the next. As such, either our staff suffer and pay the costs when we are hit with large cost increases, or services are reduced to our communities. Multi-jurisdictional community service boards are already participants in the state retirement system, so ample precedent exists for considering them as state employees for the purpose of health insurance. Additionally, allowing multi-jurisdictional community service board employees to participate in the state employee health plan has relatively low risk to the state plan. This change will have a major impact in improving the ability of our and other rural CSBs to provide mental health, substance use, and developmental disability services to the adults and children who rely upon us. Lastly, as I was coming here today, I received an email from a staff mine who wanted me to share this information with you. The largest area of concern is the insurance costs for family plans. Before employment with RRCS, I worked tirelessly to start and grow my family's small business. I'm fortunate that my husband was willing to take it over once I decided to get back into my field of study. I love working, but if I needed this job for income, I would not be able to work at RRCS simply because of the cost of health insurance premiums. Right now, I pay approximately $18,500 a year for medical and dental insurance. I have a single mother friend that put her notice to leave her previous job to work for RRCS. She was shocked to find the cost of insurance for her and her 2 young children. She ended up getting her children on Medicaid, but because her salary was already on the borderline when there was an increase in pay, her children lost the Medicaid. This is a professional, educated woman that has dedicated her life to improving the lives of others, and her children had no health insurance because she simply could not afford it.
Thank you for your testimony. So I take it in the larger CSBs that they already have insurance through the local government?
If they are a member of single jurisdictions, they would be part of the local government plans, correct?
Okay. Are there anyone else in the room who needs to speak on this bill? Anyone in Zoom waiting to speak on this particular bill?
Those in Zoom who wish to speak on this bill, please raise your hand electronically. There are no speakers, Mr. Chairman.
Okay, there's a motion and a second to report and refer to finance. All in favor will vote aye.
Ayes 15, no 0.
Okay, Senator Vogel, you have another bill?
Thank you, Mr. Chair. I do, and I have an amendment. It's Senate Bill 1375, and I'd like to move the amendment.
Okay, Okay, there's amendment in the nature of a substitute or a line amendment?
It is, I guess it's amendment in the nature of a substitute.
Okay, all in favor of adopting the amendment in the nature of a substitute will say aye. Aye.
Aye.
Any opposed? Okay. And council, is that going to be online now? Okay. Do you want to explain that, Senator Vogel, and your bill overall?
Yes, just hold on 1 second. Okay, are the people who wish to speak to this bill present in the room? No? Yes, okay, great. Just wanted to be sure, because I knew some were still in another committee. Okay, Mr. Chair, I bring this bill to you as I believe it is an important measure and not different than what we already do in state contracting. And in this case, what this bill says is that if you engage in discriminatory business practices, and in this case, that is, you are a company that has as your business practice to boycott Israel, or to have as a policy, you do not do business with Israel, you do not do business with Jews. If that is your policy, then what this says is that the Commonwealth of Virginia, as part of our procurement, we will not engage in contracting with that business. That's a long-winded way of saying it's just like we do with other prescriptive language that we have that says you can't discriminate, we won't do business with companies that discriminate, we require a drug-free workplace. It's no different than that. And for those...
Senator, if I could just interrupt you for a second. The bill before me, the substitute, refers to people who are boycotting Israel. It doesn't mention people of the Jewish faith. Am I missing anything?
No, it just says people who boycott Israel.
Okay, thank you.
Right. And so, yes, just people who boycott Israel. But to be clear, and just to narrow this so that people, to finish the explanation, this applies to a contract in excess of $100,000 with a business that employs 10 employees or more. And that would be during a 12-month period. There are 33 states who have laws that do not allow companies to contract with that state if they boycott Israel. And to be clear, this does not trespass on any company or individual's speech right. That's very important to understand. That does not mean that a company or a CEO cannot express their speech rights on Israel. They can't express hate. They can't express any other extreme or offensive statement. It just means that the Commonwealth of Virginia will not subsidize that with taxpayer dollars for a company that has a boycott policy with Israel. It also applies to, no, that part's gone. Okay. So I think it's pretty fair and a pretty fair statement, and I think we can do what 33 other states have done. I know there are people who would like to speak to this, and I would like, Mr. Chair, for you to offer them that opportunity.
Please, witnesses who are in favor of this legislation, please come forward and introduce yourself and tell us why you're in support.
Good afternoon. I'm Ephraim Seidman, Chair of the Israel Advocacy and Education at the Jewish Community Federation of Richmond. The Jewish Community Federation of Richmond is strongly in favor of SB 1375. Boycotts are not new. Jews experienced them in the 1930s before things got much, much worse in Nazi Germany. The U.S. experienced them in the early 1970s in the form of an oil embargo in retaliation for U.S. support of Israel in the Yom Kippur War. This ultimately led to the formation of the United States Office of Anti-Boycott Compliance that required U.S. persons to refuse to participate in unsanctioned boycotts. Today, there's a new type of boycott of Israel. It's called Boycott, Divest, and Sanction, or BDS. The movement's ultimate goal is to use boycott, divestments, and sanctions to destroy Israel. As stated by co-founder of BDS, Omar Barghouti, definitely we oppose a Jewish state in any part of Palestine. Is this the voice of a man who wants to bring about political change? Hardly. SB 1375 very simply ensures Virginia taxpayer dollars are not subsidizing an anti-Semitic effort to achieve what boycotts, what enemies of Israel failed to achieve with violence and war, the destruction of the state of Israel. From a legal perspective, there's no difference from prioritizing veterans in hiring process or minority-owned companies to obtain contracts with the Commonwealth. But are such anti-boycotts constitutional? Most definitely. This law has been crafted to steer clear of any restraints on an individual's First Amendment rights. Therefore, these anti-boycott laws are not intended to constrain an individual's right to boycott, but rather these laws are intended to make clear that the Commonwealth of Virginia does not wish to use taxpayer money to support companies who engaged in discriminatory boycotts of Israel. Anti-boycott laws are in line with that tradition of ensuring that taxpayer values are reflected in with whom the Commonwealth does business or invest. Most importantly, this legislation does not impede an individual's First Amendment right or strip them of their ability to boycott, as this legislation does not prohibit individual boycotts of Israel. And finally, this legislation is narrowly targeted entities who have contracts with the Commonwealth above $100,000 threshold and have more than 10 employees. To date, as Senator Vogel mentioned, 33 states across the United States have advanced similar policies that curb investment in or contracting with entities that engage in a boycott of Israel. With widespread support of leaders across the political and religious communities of Virginia, and with your support, the Jewish Community Federation of Richmond sincerely hopes Virginia will become the 34th state to do so. Thank you for your time and for your support of SB 1375.
I do have one question.
Yes, sir.
Can I ask, do you know if there are any large state contractors that are currently boycotting Israel? Is that currently a problem here?
I do not know of any.
Okay. If there are other witnesses, come forward, and if you could be brief, because we've got if there are other speakers.
Absolutely. Good afternoon. I'm Vicki Fishman. I'm the Northern Virginia Director of the Jewish Community Relations Council of Greater Washington. We are the public affairs arm of the organized Jewish community, representing a Jewish population of more than 150,000 people. I am here today on behalf of my community as well as the Jewish communities throughout Virginia. The JCRCs of Northern Virginia, Tidewater, Richmond, and the Peninsula have all worked together along with our national partners, and together we are supporting this bill. If I could just, I really have nothing to add. He spelled out Ephraim spelled out the case very well. I just wanted to point out the exchange between you, Senator Vogel, and Chairman Eben on the distinction between whether this is saying you can't do business, whether BDS is targeting Jews or Israel. The vast majority of American Jews feel as part and parcel of their identity is a connection to Israel. That is part and parcel of who they are. There is one Jewish state in the entire world. This movement is targeted to bullying, and I don't know of any current contractors that are being targeted here, but there are contractors throughout Virginia that have relationships with Israel, Pepsi, Atria, Zim, all of those, and we could have more. There are millions of dollars of investments in Virginia that will be at risk if this movement is allowed to take root here, and if we don't send a clear message that it's not that kind of intimidation and anti-Semitism is not acceptable here in Virginia.
Mr. Chairman?
Senator Mason.
I couldn't agree more. Racism, anti-Semitism is abhorrent. How would we know? I mean, do they post on their website that they boycott Israel? Or, I mean, would we have them answer a questionnaire that says they affirm positively they don't boycott Israel? And because you just said yourself, look at all those big companies in Virginia doing business with Israel.
I believe what the statute says is that if you are contracting with the state of Virginia, you would certify that you are not participating in the boycott, divestment, and sanctions movement.
Well, it says boycott. Boycott is what this bill refers to.
Okay.
Yeah.
So that you're certifying that you are not participating in a boycott of Israel.
Thank you, ma'am. Thank you.
Mr. Chair.
Senator Hashmi.
I certainly agree with Senator Mason that racism, anti-Semitism, any kind of bigotry is absolutely abhorrent, and we certainly don't want to do anything in the Commonwealth that would allow it to proliferate. If the goal is to address the issue of anti-Semitism, I think the heart of anti-Semitism lies in the white supremacist movement. When we had white supremacists marching in Charlottesville, and they united around a very horrible rally, Jews will not replace us. That is what we ought to be focusing on. Those are the kinds of individuals and movements we ought to be seeking to address and suppress and absolutely eliminate from our society, and certainly from Virginia. I don't see how this bill would address the heart of the radical white supremacist movement that is really, really inflicting great harm to the Jewish community and also to many minority communities. If you could just kind of address that.
Sure, I'd love to. Thank you.
Senator Stewart, I'm going to let the witness answer first, and then we'll call on you.
So I would like to respectfully agree and disagree. The white supremacist movement is absolutely a problem for anti-Semitism. It is not the only problem for anti-Semitism. Anti-Semitism is Jews experience hate from right, left, and center. And white supremacy is a significant problem that we as a community need to address, but so is anti-Semitism and hatred coming from the left, from Israel haters. It's not exclusively on the right. In terms of this bill is not actually specifically. It is not single-handedly addressing anti-Semitism. What it is saying is we are not allowing our tax dollars to go towards an anti-Semitic industry or endeavor.
Mr. Chairman.
Senator Stewart.
I don't quite understand how members of this committee conflate the two issues. None of us up here condone the activities of neo-Nazis and the things that they do against the Jewish population or the things that have been done throughout history. But what they're talking about is discrimination against a people. And that's one element of it, and we have the opportunity to say, we're not going to deal with you if you discriminate against the Jewish people in Israel. So I don't know why we conflate the two issues. I mean, this is a great example of where you're letting perfect be the enemy of good, to quote one of my friends who said it on the floor the other day. We have an opportunity to deal with discrimination here. We know it's happening. They're concerned about it. So why not pass this bill, and then we'll get another bill to deal with the neo-Nazis?
Thank you. Okay. Are there others waiting to testify for or against this legislation? Why don't you come forward to the microphone, introduce yourself, and please be mindful that there are others behind you waiting to speak as well.
Hello, my name is Serena Elliott, and I'm an organizer for Virginia Student Power Network. VSPN is a grassroots organization that works with hundreds of students from across the state. I am here today to express VSPN's strong opposition to SB 1375. I want to first point out that it is disturbing to even think that this body would stifle Virginia's amendment to free speech, including the right to boycott. In the long history of people's struggle for freedom and liberation, boycotting has been an instrumental tool to fighting all forms of oppression, from the boycott of British goods in the 1970s by American colonists to the Montgomery bus boycotts of the 1960s. If this bill was allowed to be enacted, tell me this: where and when does it get drawn in the line? Does the line get drawn where the government can limit Americans' free speech? Or is the government's limitation of free speech okay as long as it affects leftist and decolonization movements, movements primarily led by Black and brown people and our allies? This leads me to my second point. The time in which we are now, every American is faced with the choice. Either we support the movement for Palestinian liberation, or we remain complicit as the Israeli government continues to discriminate, criminalize, imprison, displace, and commit ethnic cleansing against Palestinians. In short, this bill is disgraceful. It not only further chips away at our democracy and freedom at home, but also further infringes on Palestinian people's dignity. We are also here to voice the opposition of this bill from several student groups, such as the Students for Justice in Palestine chapters at the University of Virginia and the University of Richmond.
Thank you.
Again, I urge you all to vote no. Thank you.
Thank you for being here today. Are there any others who wanted to speak on this particular bill?
Thank you for allowing me to speak on this important issue. My name is Zaina Shawi Hutchison, and I live in Loudoun. And I ask the committee to kindly vote no on SB 1375. SB 1375 would silence legitimate and constitutionally protected criticism of Israel and its human rights abuses. You are being asked to make people, including Virginians, your constituents, to take a loyalty oath to a foreign government. And if your constituents refuse to take that oath, not only could they be fired, but also fined for exercising their right to boycott, which is protected by the First Amendment. The consequences of this bill go beyond infringing on the rights of Virginians, your constituents. SB 1375 contributes to the continued oppression of a whole nation of over 14 million who have been subjected to gross human rights violations by Israel for decades. Therefore, the patron of this bill and its supporters want you to become complicit or to be complicit in Israel's widely documented human rights violations in preventing Palestinians and their supporters from advocating for Palestinian rights. I am Palestinian born and raised, so if I speak up, my whole presence here, this whole bill essentially is saying nonviolent resistance is banned, and that's unacceptable. Don't allow special interests and the political interests of a foreign government to encroach on our commonwealth. Protect your constituents' freedom of speech and Virginia's political integrity. And I ask that you vote no on this unconstitutional bill. Thank you for your time.
Thank you. Were there others in the room today? Yes, please come forward and just line up at the microphone, if you will.
Thank you. My name is Paul Norsey. I'm from Vienna, Virginia. I'm the co-chair of the Virginia Coalition for Human Rights. We are strongly opposed to SB 1375 for several reasons. One, it would violate the First Amendment rights of all Virginians. Two, it reintroduces a bill which has already been twice rejected by the General Assembly in 2016 and 2022 because of it's unconstitutional. And three, it would silence legitimate and constitutionally protected criticism of a foreign government for human rights abuses. We think this bill clearly aims to restrict our constitutional rights, including the right to criticize any government, foreign or domestic. The bill is also aimed at, it was initially also aimed at restricting academic freedom. I see it's been amended to remove that part. I will point out that there are many organizations, civil rights organizations, including many Jewish groups, Jewish Voice for Peace, which is a member of our coalition. We have 19 member organizations that are strongly opposed also to this bill. That's what we're here representing. The ACLU of Virginia has been on record opposing this bill last year, and the Center for Constitutional Rights has opposed this bill in other states where it has been attempted. Wherever it has passed in other states, it's been taken to court and defeated. It has gone to appeal in one state, I think Kansas or Arkansas, and it's now going to the Supreme Court, where we hope it will be struck down as unconstitutional. We have, boycotts are an American tradition. Come on. The first Congressional Congress of the United States, their first act was a boycott of British tea from India. All through the Montgomery bus boycotts, the boycotts of Russia and China, now, today. we as Americans have the right to boycott. And, it's just completely unconstitutional to demand that people and companies not participate. And how do we prove we don't participate? If I'm a company doing $100,000 worth of work with the state of Virginia, do I have to then do business with find some way to do business with Israel to prove I'm not boycotting them? How do I do that? So for all of these reasons and many more, we ask all the members of the General Assembly to vote no on HB 1375 and protect the First Amendment rights of all Virginians.
Thank you.
Thank you very
for
much.
being here. I didn't put a timer on the speakers, so the remaining speakers, if you could be brief, if possible, that would be helpful.
Certainly. My name is Catherine Akbar, and I'm also with the Virginia Coalition for Human Rights. I'm a member of the Virginia business owners community, and I urge you to defeat this punitive bill. Members of the Senate should be in the business of supporting local businesses, not punishing them or mandating their business practices as they relate to doing business with a foreign country. I choose not to do business with apartheid states, including Israel, not because I hate it, Senator, but simply because I have lived under the brutal Israeli occupation, and my ex-husband was imprisoned and tortured by that government for his nonviolent political activities. And even if you hold a different opinion and haven't had the opportunity to live in occupied Palestine, I hope you recognize the First Amendment right to free speech and the right of business people to freely choose any business practices that do not discriminate against any protected class. Foreign countries do not fit this definition and are not your constituency. Thank you.
Thank you.
I'll be very brief. My name is Maher Mazzas. I'm with the Virginia Coalition of Human Rights. When we're talking about conflating, why is it that anybody who criticizes Israel is always called anti-Semitic? It's not anti-Semitism to criticize Israel. Nobody is criticizing Israel because the majority of citizens happen to be Jewish. Let us assume that the majority of the Israeli citizens are Christian or Muslims or Buddhist. The criticism of Israel will continue because of its policies of discrimination against the people who live there. And so it is not anti-Semitic to criticize Israel. And please, let the companies boycott any country they want. This is America. We live in a free country. And so please uphold our constitutional right to boycott. Thank you.
Thank you. Are there any speakers in Zoom waiting? Were you waiting to speak on this bill? Please come forward.
Hi, Mr. Chairman. Thank you so much, Mr. Chairman, Senators. My name is Elon Carr, and far from being here on behalf of a foreign government, I was the United States Special Envoy to combat anti-Semitism around the world. And the movement to boycott Israel is nothing more than the age-old cry of don't buy from the Jews. That's what this is. And what this bill doesn't do is pick out different flavors of anti-Semitism. Senator Hashmi, white supremacists were the first to say don't buy from the Jews. This was a rallying cry of white supremacists and right-wing anti-Semites, as it is from radicals on the far left. Another thing this bill doesn't do, and here I want to correct misstatements that were put on the record, nothing here prohibits a contractor with the state of Virginia from criticizing Israel, condemning Israel, or even spouting rank anti-Semitism. A contractor could sign a contract over $100,000, sign the certification in the contract, and then go say, I hate Jews. I hate the state of Israel. I hate the Jewish people. Not prohibited. That would not be a violation of the state contract. Nor does this bill prohibit boycotts of Israel, which, by the way, is not First Amendment protected speech according to the Supreme Court and according to the Eighth Circuit, right? It's commercial activity, right? Refusing to deal, it's national origin discrimination. But even that isn't prohibited. A person can do it, have at it. You want to boycott Israel? You want to not buy, say, don't buy from the Jew? I'm not going to sell to Jews. I'm not going to buy from Jews. Have at it. All this is saying is we don't want the hard-earned money of hardworking Virginians to subsidize that kind of behavior. We want to stand up for American values and the values of the vast majority of the people in Virginia to say, you know what, you want to do that, go do that. But we don't want to deal with you if you're going to do that. That's what this bill does. And the last point I want to make, Mr. Chairman, because I don't think it was said clearly, The Jewish organizational community en masse supports this. And I just want to provide for the record, the Conference of Presidents of Major American Jewish Organizations endorses this. Every single Jewish federation in Virginia endorses this. Every single Jewish Community Relations Council in Virginia endorses this bill. The Jewish Federations of North America endorse this. The Anti-Defamation League has endorsed this bill. The American Jewish Committee endorses this bill. The Combat Anti-Semitism Movement, on whose board I sit, endorses this bill. This is a bill with wide consensus, tested in court, adopted by a majority of U.S. states. Majority of U.S. states have laws like this, and I ask that you pass this and stand up for what's right, and don't buy from the Jews isn't something that should be heard in the state of Virginia. Thank you very much.
Thank you. Were there anyone waiting to speak in Zoom on this particular bill?
Yes, Mr. Chairman, there is one. Simone Reed, please unmute your mic and give your testimony.
Hi, my name is Simone Reed, and I am a student at the University of Richmond and a member of our chapter for Students for Justice in Palestine. I'm here to express the strong opposition of our chapter to SB 1375. The state of Virginia should strike down this bill that is in direct opposition to the realization of First Amendment rights for the citizens of this state. The right to protest and the right to boycott is a part of the commitment in our U.S. Constitution that guarantees us free speech protected by the government. And to pass this law is to admit to hypocrisy, to greater censorship of just causes that support true freedom. Not only is this law unconstitutional, it is simply immoral. It's no secret that the state of Israel is committing what can only be referred to as an apartheid and ethnic cleansing of the Palestinian people. This has been well documented and is in clear violation of international law. Despite this, state governments have consistently demonstrated uncritical support of Israel at the expense of Palestinian life. This is not discrimination against Jewish people or Judaism, but rather a stand-in protest against violent injustice. There is no relationship between anti-Semitism and criticism of Israel. Palestinian freedom is not something that we can take a weak stance on, and therefore it is the right of any group or organization or contractor to boycott this terrible injustice and support the people of Palestine. Boycotts, as we know, helped weaken South African apartheid, and that's where the BDS movement draws its inspiration. Let us stand again on the right side of history, and for these reasons, I urge you all to vote a resounding no on SB 1375 and be on the side of freedom. Thank you.
Thank you for your testimony. Okay, we've heard quite a bit about this proposal. Is there any discussion or a motion?
Mr. Chair, just in closing, if I could.
I'm going to let Senator Vogel close, and then I'm going to give the floor to Senator Locke.
Okay, Mr. Chair, just in closing, I would like to make absolutely clear something that I think that may be confusing and may have been misstated in the testimony before the committee. And that is, this legislation and this language was very, very narrowly tailored. And I believe that many people stood up and characterized this as a violation of people's constitutional rights. And I want to be very clear that this does not impinge on anybody's speech right. What this does is it protects the taxpayer money of those of our constituents that live in the Commonwealth of Virginia. That's simply what this does, so that their taxpayer money isn't used to support something that they would not agree with. It does not in any way impose or overreach on businesses in the Commonwealth of Virginia. So I just want to say that, and I just want to say it would shock the conscience, I think, of any Virginian to think that we would do differently. So thank you, Mr. Chair.
Thank you, Senator. And I'm sorry, we've already had it. We've concluded our public testimony. No, we've concluded our public testimony. Senator Locke?
Thank you, Mr. Chair. I guess I'm confused on what prohibition on boycotting Israel means. It means prohibiting boycotting. And Mr. Chair, I don't know where there's any place else in the code that we have language that says prohibiting boycotting any other country. And I don't know where else that we as a legislative body have engaged in foreign policy making as an entity. And I don't think that we should engage in going down that road now. So, and with that, I would move that we pass by indefinitely Senate Bill 1375.
Okay, there's a motion and a second to PBI SB 1375. Clerk will open the roll. Okay.
Ayes 9, noes 6.
Okay, the bill fails to report. Are there other members with bills before us today? I had Senator Mason and, okay, if you could just be orderly, we have other business to conduct. Senator Mason, we'll hear from you, and then Senator McPike afterwards. Oh, I'm sorry. Okay, let's take you right after Senator Mason. We'll try and, okay.
We go to Senate Bill 1222, Mr. Chairman.
Okay, you direct your attention to Senate Bill 1222.
Committee, if you don't have a substitute, I move my substitute.
Second.
Can we pass that crowd around for energy and enthusiasm?
Yeah. Okay, so Senate Bill 1222, there's been a motion and a second to adopt in nature and the amendment of a substitute. All in favor will say aye.
Aye.
Any opposed? Okay.
Mr. Chairman, my apologies to the committee. This looks like a gargantuan substitute, but it's pretty basic what we're trying to accomplish. What you've heard us talk a lot about disclosure packages to common interest communities that you must provide to people that are buying. Well, it's scattered all over the country. If you look at lines 185 and 186, we strike a bunch of places that it's referenced, because this effort, starting line 655, creates, first of all, we're changing the name from disclosure package to a resale disclosure, okay? And we are trying to put every rule associated with that practice and what that entails, what it's got to say, what it's got to cover, all in one place, so we know where to find it. So we start, as good Bill would, with definitions, and then on line 691, contract for resale, the disclosures that have to be in place. Line 712, the resale certificate, which is this new, what is the form, we're trying to make that more standard, and the contents that have to be in it. Then we go down line 757, we talk about restrictions. It's sitting for that, any restriction. So anything that has to be noted there. My line's off. Then updating the certificate and any cancellation. So all we've tried to do here is take that packet you're going to buy in one of these areas and lay out what's got to be in it, what it's got to say about restrictions, how it has to pass to the new buyer, and we just are trying to put it all in one place.
Senator, is this largely consolidating existing rules, or are we adding new policies to the disclosure
Over the years, it's
area?
been picked here and there. We do clarify some things and change the format of some forms. But as far as the existing law, do we make some?
Okay, Ms. Trigiani, if you want to come, we'll have.
I don't want to say absolutely no changes when we're making some.
But largely, what we're doing is consolidating existing policy, making it easy to refer to and understandable. Okay, thank you.
For the most part, we've taken the resale disclosure language out of the POA Act, the Condo Act, and the Cooperative Act, and we've consolidated it into a separate chapter. Most of that is the same law. It's the same law, just moved to a new chapter. There are a few substantive changes. The senator mentioned it had different terminology in each act, so it's now going to be called the resale certificate. There is a new form that DPOR will provide. They've already provided a cover sheet. They're now going to provide the resale certificate form. It puts the packet of information in a standardized format for the homeowner to read and be able to find out everything. Most of the disclosures that are included in this new chapter are the same as current law. There are a few different ones that were already disclosed in separate places, and we've just pulled them out to highlight them. That includes parking and vehicle restrictions, any restrictions on home-based businesses, rental restrictions. So most of it's current law. Those are some of the newer ones that we've pulled out. There's no longer going to be a distinction between managed, professionally managed, and self-managed associations. That's kind of the highlights of it. Another substantive change that I do want to point out is that the resale certificate will now need to be paid for at the time it is ordered instead of at closing. And there is peace in the valley on that decision. We have worked very closely with the association, CAI, the managers, and want to thank Senator Mason for bringing this bill for us.
Thank you. Ms. Trigiani, did you have anything to add, or?
It's a great bill. We support the bill.
Thank you.
Thank you.
Okay. Are there any questions for Senator Mason? Are there any discussion or motions?
I have 13 people in Zoom who'd like to speak to Mr. John.
Okay. Are there any speakers? Why don't we just check in? Are there any speakers in Zoom waiting to speak on this particular bill?
Those in Zoom who wish to speak on this bill, please raise your hand electronically. There are no speakers, Mr. Chairman.
Okay. There's a motion and a second to report the amendment in nature or substitute of Senate Bill 1222. All in favor will vote aye.
Oh, yeah.
Okay. Okay. The bill reports.
Thank you, Mr. Chairman. Members of the committee, the next one's Senate Bill 1218, which in keeping with general law's tradition has a substitute. So I move the substitute, Mr. Chairman.
Second.
Motion and a second for amendment in the nature or substitute for Senate Bill 1218. All in favor will say aye.
Aye.
The substitute's before us. Senator, if you want to explain that
Yes,
in
sir.
the general bill.
Yes, sir. Mr. Chairman, a couple years ago, we put some language in the budget to try to focus on elevating the attention giving to aging in state government. Didn't go so well in the last administration, so we did it again. Took us a while to reconstitute this year, so we're going to do it again, and just to continue the discussion. But one thing that we came upon is the Commonwealth Council on Aging has been set in an established fashion for a while. By the way, I'd like to thank Rebecca Schultz for her incredible work on this bill and all the help she's given me. But they're laid out by congressional districts. And we're having a hard time finding some folks, and we just wondered why it was laid out that way. So we looked at just a different structure. We're looking at the Cooper Center's breakdown of Virginia, 8 districts. We're asking for those appointments to those 8 districts to be 4 directors of area agencies on aging and 4 people with some sort of professional or connection to the aging population. And last year, Senator Favola brought a bill to ask the Commonwealth Council on Aging to come forward with a legislative packet. Are any of you familiar with that packet? You're not, because there are no legislators on the commission. So what we thought we'd do is give the Speaker the chance to promote a delegate, to put a delegate and a non-member, the Rules Committee to put a senator and a non-member to be a part of these discussions in promoting aging, and then we want to add the director of the Virginia Center on Aging. And so we've shrunk down the commission a bit to where we have 13 members. Then we throw some ex officio in there. Initially, I had taken them out, but we had some conversations. You note it says something unusual. A deputy director of aging and rehabilitation services, if there is one, I want to see a deputy director of aging. But I'm not going to prescribe to a new administration to name one. We're going to ask them to do it. So if there's a deputy director of aging, they'd be ex officio. If not, the commissioner of DARS would be. DMAS does so much work, but we also put language in there that someone at DMAS that deals with aging issues and reimbursements. And so we're really trying to tailor it to have more folks that are dealing with this issue every single day, make the commission a little tighter with legislators. Now, I will shut up quickly, but at the very end, you'll see an amazingly, a very inventive clauses at the end. And the goal there is we just appointed 5 people, I think. I don't want to kick anybody off. So the people that just got appointed, we want to keep them on. This is the great team's effort that I had no idea how to do, to try to make sure we don't kick anybody off. But then as we appoint, we begin appointing under the new structure and reconstitute it over the next several years without kicking anybody to the curb. Mr. Chairman, I should close by saying that they may be here, but the Commonwealth Council on Aging sent me a letter saying they were opposed to the move. That was 6 days into the General Assembly session, and we hadn't even talked. But in their defense, they only meet quarterly. And finally, Mr. Chairman, so we'd like to talk to them about it because we're not shooting at anybody. In fact, what we want to do is give them a full-time executive director, because that's somebody that's job can be to drive the bus on these issues throughout the course of the year when you and I go back to things that hopefully make us a little bit more money than this effort.
Thank you. Are there questions from senators, from members of the committee for Senator Mason? Yes, Senator, yes.
Thank you, Mr. Chairman. I only have one question. If we pass this bill,
Yes, sir.
and it goes over to the other side, are you going to defend the Senate and make sure they don't get more appointments than us?
Mr. Chairman, Senator Stewart, I absolutely will, and I will not ask anybody under 18 to opine on anything at that time.
Second. There's a motion and a second to report and refer to finance. Are there anyone in the room who feels compelled to slow this train down or to speak to it?
On behalf of the Board of Directors of the Virginia Association of Area Agencies on Aging, the board voted unanimously, strongly support the bill, and asked me to come say that to you.
Thank you. Okay, great. Is there anyone in Zoom waiting to testify on this particular bill?
Those in Zoom who wish to speak on this bill, please raise your hand electronically. There are no speakers, Mr. Chairman.
Okay, I believe there was a motion and a second, if I heard properly, to report and refer to finance?
Yes, sir.
Okay. All in favor will vote aye.
Ayes 15, no 0.
Thank you, Mr. Chairman, members of the committee.
Thank you. Senator Hashmi, you had a bill. Or two.
Thank you, Mr. Chair and members of the committee. I'm going to start with, I've got two bills, so I'll start with SB 937. And I think everyone is going to love this because it's about television, and it's about making shows, and it's about jobs. So we have great enthusiasm for this particular bill, I know. This is called the Lights, Camera, Jobs Plan, and it's a comprehensive agenda to modernize Virginia's economic investments in film production as well as workforce development. So Virginia is one of 40 states that utilizes incentives for film and television projects, and it's easy to see why. Just one single substitute. There is a substitute.
For 937? Okay. Okay, it's been moved and seconded that we adopt the amendment in the nature of a substitute for SB 937. All in favor will say aye.
Aye.
Any opposed? Okay, the substitute's before us. If you want to, as you explain the bill, perhaps you could tell us if there are significant changes.
I think there are just some technical changes, Mr. Chair. It's just giving the date that the report will be due to the General Assembly by a certain date, and clarifies that the employment will be through the program, and it also indicates that the first report is going to be filed with our Virginia Tourism Authority. So just a few amendments.
These were actually technical amendments, so I'll accept that motion as adopting the amendments. Okay. Is that complete your presentation?
No.
No, please continue.
It interrupted my wonderful presentation. Okay, that was my fault. So we're really looking at bringing a wide variety of jobs to Virginia, lucrative and highly skilled jobs as well. And this includes everything from set builders to electricians to truck drivers to our restaurant and hospitality industries. But when we're taking a look at where we are as a Commonwealth, Virginia is not competing with so many other states. We've seen our counterparts strengthening their incentives in order to diversify their economies with jobs that are really bringing a great deal of economic growth to their particular states. So we see Georgia, North Carolina, and West Virginia having adapted already to a changing marketplace, but Virginia, unfortunately, has remained stagnant. And this particular bill is designed to take us to that new level. This plan will make Virginia's existing incentives comparable to other states in the region. It also will prioritize television in order to create year-round pipeline of jobs. So it's not just a one-time opportunity, but a continuous program that will bring jobs to the Commonwealth and continue to expand those jobs as well. And it is also designed to train and retain our creative workforce. We've got a lot of wonderful folks coming out of Virginia colleges, universities, and training programs, but they are actually leaving the Commonwealth and going to other states in order to find jobs in this creative area. So by investing in an apprenticeship program, we would continue to not just train individuals, but help to keep them in Virginia so that they can continue to contribute to our economy as well as to this growth opportunity in this industry. And we do have Andy Edmonds here who can speak to some of the technical areas of implementing this particular plan.
Okay. Mr. Edmonds, please introduce yourself and tell us why this is a good thing.
Thank you, Mr. Chairman. I'm Andy Edmonds. I'm the director of the Virginia Film Office. I've been with the Film Office for 25 years, but primarily before that, in 1976, I was a Senate page right here, so I'm very respectful of this body and thankful to be here speaking to you in this context. So, Senator Mason, when I would talk to my 14-year-old daughter and tell her that when I was her age, we had 3 television stations, she would look at me like I'm crazy. Now there's unbelievable number of platforms, streaming services. There's created this global demand for content to fill up all of these platforms. The creation of this content is actually manufacturing process, as Senator Hashmi pointed out, that includes all of these skilled tradespeople, technical people, and actors also, of course. But all these different jobs, different states, different countries, provinces want this work. And it used to be we would compete with great locations and great logistical solutions, but now really incentives have become really the way to have to attract this work. And at the end of the day, you have to buy the jobs, and I've seen this, I've witnessed it over the years, but really with episodic content, you're able to create jobs that demand sound stages, for example. We have no sound stages in Virginia right now. There are 115 in Georgia. So I'm here just to provide technical information about the industry, not to speak particularly for the bill, but I can tell you that inducing episodic content television is better than the one-off projects. However, we do like to pursue specific projects that have great Virginia added value, that can contribute to tourism opportunities. For example, with Wonder Woman 1984, they had a great product placement with the Virginians for Lovers logo in the movie. Senator Evan, I think you remember seeing that. They had the big logo of Virginians for Lovers in the movie. That show was here for just 13 days. They spent $24 million in 13 days of production in Northern Virginia. It just coming out of the pandemic, we had 4 episodic television shows that spent over $120 million. They were the first tourists to come to Virginia were filmmakers. They're really like super tourists with a payroll. So between Swagger, Walking Dead, Dope Sick, they spent over $120 million in direct spending. So anything we can do, I feel, for our industry to induce episodic content in television is really a smart idea.
Is there a budget amendment or an administration appropriation in the budget to fund this? Yeah.
Yes, we have filed budget amendments.
Thank you.
As well as for the apprenticeship program through our community colleges.
Okay, thank you. Are there other questions?
Move to report as a substitute and refer to finance.
Okay, a motion to report the substitute and refer to finance. All in favor will vote aye.
Ayes 13, no 0, 1 abstention.
Does somebody have voice goes? Okay.
Okay. Oh, well, the bill reports. Okay, or report and refer. Okay, then you have another bill, right?
Yes, Mr. Chair, we have SB 941. This is the bill that we heard last week, and we had passed it by for the week so that we could continue to work with our stakeholders. You may recall this was the issue that was addressing the concern around security deposits and the opportunity to ensure that tenants are able to receive their security deposits in a timely manner. And there is a substitute.
Is this the substitute that we already adopted last week, or is this a new substitute?
This is the new substitute.
New substitute.
Thank
okay.
you.
So there's a motion to adopt the substitute in a second, and all in favor of adopting the substitute will say aye.
Aye.
Any opposed? Okay.
Thank you, Mr. Chair and committee. We did do our best to work with a variety of stakeholders. I don't know that we've reached full agreement, and I'm sure you will hear from some of our stakeholders today. But in a good faith effort, we eliminated the changes that we had initially made, reducing 2 months security deposit to just 1 month. We took all of that language out. So the focus of the bill now is really to allow tenants to have the opportunity to be present at the time of the final inspection as they're leaving a rental unit. If they are able and if they desire to do so, the tenant has the right to be there. And then also, we are expediting the return of the security deposit to the tenant. This is money that is legitimately the tenant's. And so if an individual, if a tenant is leaving a rental unit without any damage, adhering to what their commitment and their contractual obligations were, they have a full right to have their money returned to them in a timely manner, to not wait for 45 days or 60 days.
I think Senator Pike has a question.
So we heard a lot of this last week, right?
Yes,
and
we
so
did.
there's now agreement to get it to 15 days, just to narrow down. That's where we're at today. And I think last week it was 5 days, and we had a whole debate. So the substitute now gets us to 15 days. Is that correct?
15 business days, but I can't say, Senator, that we have full agreement on that.
Thank you.
But that is the main change, 15 business days.
Okay. Could we have those who'd like to speak for the bill come forward and tell us why it's a good thing?
Thank you, Mr. Chairman, members of the committee. Christy Mero with the Virginia Poverty Law Center. We want to thank Senator Hashmi, and I particularly want to thank Aaron Corman with the Realtors for working so hard with us to arrive at this language. We do support the bill. As the Senator said, we think it's important for good tenants who have complied with the rules, not caused any damage, paid all of their rent, and who are present at the move-out inspection to be able to get their deposit back as quickly as possible so they can continue to be good tenants and use that deposit to pay rent or a mortgage at their new home. And so we support the bill, and we thank the Senator.
Thank you. Good evening.
Evening, Mr. Chair, members of subcommittee, members of the full committee, pardon. Sheila Hurley with the Virginia Interfaith Center for Public Policy. We agree with the Virginia Poverty Law Center, appreciate the patron bringing the bill, and support it. Thank you.
Thank you.
Isabel McLean with Housing Opportunities Made Equal of Virginia, and we support the bill.
Thank you.
Aaron Corman with the Realtors. At your request, we did take it back to our members. We've worked with the Poverty Law Center over the past week, and I think this is something our members can live with. So thank you very much.
Thank you.
Mr. Chairman, Randy Grumbine representing the Virginia Manufactured Modular Housing Association. We can support the changes that were made to the bill. Thank you, sir.
Thank you. Okay, any opponents? Okay.
Good afternoon, Bisma Ahmed with the Apartment and Office Building Association and the Virginia Apartment Management Association. We certainly appreciate the intent of Senator Hashmi and what she's trying to achieve. We are certainly supportive of the provision allowing tenants to be present at the inspection. Our issue lies with the timeline. Our managers and owners usually aren't aware of the full extent of damages until after inspection. For instance, housing providers may use that security deposit for delinquent accounts, third-party billers like cable providers, utilities, and if a tenant skips out on their last utility bill, we usually don't know until 15 days after or well after that. So, when our housing providers aren't liable, they're, worried about being liable when they're working with third parties in that timeline. So for that reason, we ask that you oppose. Thank you.
Are you liable if someone skips on their cable TV bill or something?
So that's where we use that security deposit. But we usually don't know if the utility bill isn't paid until after 15 days.
I see. Even if it's in the name of the tenant, you think you would typically be liable?
Yes, so we would need to know if, that security deposit has been paid. So we don't know until, longer into the timeline. So that's where our members are concerned.
Okay, any other questions?
I'm sorry, I didn't understand that, Mr. Chairman. So my tenant skips out on me, has an account with Verizon and doesn't pay it. It keeps showing up in the mailbox after they're gone. Are you claiming that I'm liable for that Verizon bill that's in their name?
No, but housing providers will typically use that security deposit and, for that utility bill.
Mr. Chairman,
Senator
I
Mason.
appreciate that, but you're not responsible for it. You've got money that you can pay, but they're not coming after you because it's in my name, right? So why would you use my money to settle a contract that you're not a part of? And I know you feel like we pick at you all the time. I'm so sorry.
No, you're fine.
Mr. Chairman,
Brian.
if I may,
Yes.
Brian Gordon, also with the Apartment and Office Building Association. Yes, actually, if for instance, a utility bill, an electric bill, a water bill, that can result in a lien on the property itself, even if the billing is in the name of the tenant.
So, Mr. Chairman,
Senator Pillion.
It reverts back to the property owner is what you're saying?
That's correct,
Okay.
and that's exactly the reason that we stand opposed. Again, we're very sympathetic with the intent of the bill, but again, we don't know the full extent of the damages until well after that 15-day timeline.
And how much time would you want to hold that deposit?
Mr. Chairman, I think the existing law is 2 months, I believe. And I think, again, if it's in the tenant's name, we're not necessarily receiving that bill at the end of the month. And so my understanding is that members have been able to work under that 2-month timeline.
Thank you. Okay. Are there any other questions from members of the panel, or does anyone in Zoom want to testify on this particular bill?
Yes, Mr. Chairman, there's one speaker, Victoria Horick. Please unmute your mic and give your testimony.
Thank you, members of the committee. Mr. Chairman, my name is Victoria Horak. I'm an attorney at the Legal Aid Justice Center, and I represent low-income tenants. We support the bill for the reasons that Christine Mara of the Poverty Law Center stated. Our tenants have a lot of difficulty finding housing in this rental market, and usually they need to get their security deposits back before the next month of rent, or as soon as possible. They might be able to get 1 month's rent at a new place, but then being able to get the deposit back in less than 30 days would allow them to put the deposit toward another month of rent. So we support the bill. Thank you.
Thank you. Okay. Were there motions or discussion among members of the committee?
Move to report.
Motion to report in a second. All in favor will vote aye on the electronic voting board.
Ayes 8, no 6.
Okay, so that bill is reported. And then who's waiting? Senator Barker and Senator McPiker had bills. Senator Barker, do you want to go ahead?
Sure. Who's getting Boy Scouts? Oh, Bell.
Before the committee today, starting out with Senate Bill 1341. What this does is that it addresses an issue that has arisen among non-profit type of organizations, charitable organizations that operate in many things, and also there are religious churches and synagogues and other facilities that are that need to be handled in particular ways. And what often some of the religious groups have done is have appointed trustees. What we've run into is a situation where some of the society and group associations, posts and those types of things that are nonprofit it's in the code to allow circuit court judges to appoint trustees to those operations. But what has been happening is that some judges and some courts have said, well, it doesn't require us to appoint trustees, so we're not going to do that. And that ends up creating problems and the one person who brought this to me, a constituent of mine, is a leader in the the Virginia Masonic Lodges. And so this is the Masons that have been around for a couple of hundred years, and they've been encountering problems in many instances in many courts in terms of getting trustees appointed to be able to supervise the properties. I mean, for example, right across the parking lot from my office, my legislative office I have in the town of Clifton, there's a Masonic Lodge right there, and that's in a property that's operated by the Masons. And they've been fortunate in that they've been able to get the Fairfax County Circuit judges appointed trustees. But they've said that a lot of the facilities around the Commonwealth have not had that same courtesy extended. And what the intent of this bill is basically just to state that to require the judges to make the appointments of the trustees.
Okay, are there questions for Senator Barker? Is there anyone in the room who'd like to speak for this fine bill? Anyone who'd like to speak against this fine bill? Is there anyone in Zoom who wants to speak on this particular bill?
Those in Zoom who wish to speak on this bill, please raise your hand electronically. There are no speakers, Mr. Chairman.
Second.
Okay, motion and a second to report Senate Bill 1341. All in favor will vote aye.
Oh, Senator Barker, I'm sorry.
Yeah.
Okay, the bill reports, and then your other bill.
Yeah, the bill is 1340, and this deals with the Residential Landlord and Tenant Act, and this is relating to what types of information must be provided to someone who comes in to be able to rent an apartment or other accommodation there. And if you look at the key to this bill is on lines 96 through 103, that says that a landlord should not obtain any consumer report or conduct any other investigation into the background or qualifications of a rental applicant without first, little I1, establishing a written rental application policy that's available to the public and includes a disclosure of the amount of all of non-refundable application fees and deposits, and 2, providing the applicant either a copy of the landlord's written application policy or an electronic communication stating where the landlord's written application policy may be accessed and providing a hyperlink or other electronic access to such policy. And so this also may be put on the website available to the public. But this is designed to not, in effect, have someone apply to rent an apartment, get approved, and then get rejected, and sometimes some of the fees that had been paid up front are not returned in those situations. So that's what we're trying to address with this bill.
Thank you, Senator. Are there any stakeholders from the either tenant or landlord community who'd like to weigh in? If you love it, you can just.
Thank you, Mr. Chairman, members of the committee. Christy Mero with the Poverty Law Center. We thank Senator Barker for bringing this and thank all the stakeholders. We work together on this legislation. I like to call it the Truth in Renting Act because it really is about transparency. It's about making sure that a tenant or an applicant knows how to qualify for a space, whether or not they'll qualify based on the criteria that are published, and how much money that they will have to pay. It helps people make good decisions for themselves about their housing, and we ask you to support the bill.
Thank you.
Mr. Chairman, Erin Corman with the Realtors. We also support the bill.
Thank you.
Mr. Chairman, Isabel McLean with Housing Opportunities Made Equal, and we support this bill because it will remove a significant barrier to rental housing. When the application process is unclear, applicants pay the price in the form of unnecessary fees. And we think this added transparency is just a good business practice that all housing providers should engage in. Thank you.
Thank you, Mr. Chair. Sheila Herlihy with the Virginia Interfaith Center for Public Policy. We also support this bill because those non-refundable application fees do add up. And there are families that I've known personally who have really struggled to find a place where they both qualify and can afford after paying a number of those non-refundable fees and being denied. Thank you.
Thank you.
Mr. Chairman, members of the committee, Bisma Ahmed with the Apartment and Office Building Association and the Virginia Apartment Management Association, and we support the bill.
Thank you.
Mr. Chairman, Randy Grumbine, Virginia Manufactured Modular Housing Association. We too are in support.
Thank you. Okay. Is there anyone anyone in Zoom who feels compelled to speak on this bill?
Yes, Mr. Chairman, we have one speaker, Victoria Horrick. Please unmute your mic and give your testimony.
Members of the committee, Victoria Horak, Legal Aid Justice Center, we support the bill. I work with a lot of clients who have housing choice vouchers, and these are subsidies that help them pay the rent. They don't help pay these types of application fees, and so sometimes a tenant, even when they have the ability to go move from one place to another and find affordable rent for themselves, they actually can't rent because of high application fees. So having to pay them for a lot of places where they won't end up being eligible really puts a burden on those families. This would help them target their apartment search to places that they'll actually find stable housing. So we support the bill.
Thank you. Okay, was there any discussion or motions on this
Move to report.
Second. Okay, there's a motion and a second to report Senate Bill 1340. All in favor will vote aye.
Ayes 15, no 0.
Okay, Senator McPike.
Did you want to pass by for the day?
We have two bills from Senator Deeds, who unfortunately isn't going to be able to make it. So Senate Bill 1308 and 1309 will go by for the day unless, do we need a motion for that, Eric? Okay, is there a motion?
Second.
Okay, moved and seconded to take 1308 and 1309 by for the day. All in favor will say aye.
Aye.
Any opposed? Okay, so those are by for the day. Senator McPike, you're up.
Thank you, Mr. Chairman. This is Senate Bill 1036.
Okay, we'll direct our attention to Senate Bill 1036, please.
Thank you, Mr. Chairman, members of the committee. Senate Bill 1036 removes the exemption for the Virginia Tourism Authority to not have to apply the Virginia Public Procurement Act. As you know, this year there's probably a little controversy in terms of the selection process, in terms of a media contract that happened earlier this spring. There was an OIG report that said nothing's wrong. Well, in fact, if you actually look at it, what's really wrong is the fact that they're exempt. And if you look through the organization's rules, the director themselves can basically make any rule they want. And when this happens, I think this is when it causes us pause and we need to do a second check. We have exemptions in our Public Procurement Act, and when things happen, we need to pull that control back, and that's what this does. What this bill does. And further up, there's additional reports that found that more than 125 no-bid contracts were awarded since 2017, totaling of $11.8 million. And I think when we have that sort of issue, we need to pull it back and reset and remove entities from exemption from the Public Procurement Act in order to follow the basic tenets of public procurement, because the reason why we have this act is public trust. And that is a tenet of why we have this exact act in place. And when we have organizations not following those tenets, we need to remove those authorities. And that's what this bill does. You'll hear, from folks, and I'm sure you have, that the sky's going to fall. They're not going to be able to procure different media efforts, and tourism's going to fall off the cliff. Well, it's just not true. You have existing efforts within the Virginia Public Procurement Act you can do for multiple award schedule contracts and selections to have multiple media firms available to you at your disposal and have those contracts set and ready to go and respond to any organizational need. I've done it for 20 years. There's plenty of ways to structure it, and I no longer find the need to have this exemption for this organization, Mr. Chairman.
Okay, so basically they would follow the same procurement as other public entities.
That's correct.
Okay. Are there questions for Senator McPike? Is anyone here who would like to speak on this bill in person or via Zoom?
Those in Zoom who wish to speak on this bill, please raise your hand electronically. There are no speakers, Mr. Chairman.
Okay. Are there questions from a member of the panel or motions?
Move to report.
Move to report, and a second. Is there a second?
Second.
Okay. It's been moved and seconded that SB 1036 be reported. All in favor will vote aye. Okay.
Ayes 11, no 0, 3 abstentions.
Okay, and Senator McPike, did you have a second bill? Nope, okay. Is that complete our agenda from those in the room? Okay. So thanks everyone for bearing with us. Hopefully next week's meeting will be a little bit shorter.
Way to go. Way to barrel through that.
Well, maybe a time will